Hi, everyone. Welcome. My name is Lacey Jane. This is Criminally Confident. And I was scheduled to come to you guys at 3:45 p.m. Eastern today, but it looks like we have a verdict in the Suzanne Mericle case. So if you haven't been watching, basically, I'll give you a rundown of what's been going on. We have a prestigious dentist who lived on St. Simon's Island in Georgia. And this woman, all she wanted was love. That's all she wanted, according to her. And she met this man a while back. They dated. It didn't work out. They got back in touch and it just went super fast from there. They got a house together and the mortgage was $9,000 a month. And there were a lot of issues. Family members knew that there were issues at one point. Well, not at one point, up until his untimely passing. He was actually giving a mother and daughter in Romania $3,500 a month to move to America. And it's very sus. This is a very it's a bizarre case. You know, she ended up getting into an altercation with him and she basically took her firearm, and I have to watch my language because of YouTube, and shot it into a locked door where he was. Allegedly, he was hiding her phone, her keys, so that she couldn't leave. And so she couldn't open the door, was trying to open the door. And sorry, we're still getting things together over here. Shot through the door and fatally wounded him. And she's claiming that this was a self-defense case. And so that is why we are here. Hello, Mitchell. If you are watching live and even if you are watching on replay, please make sure to hit the thumbs up on YouTube and the heart on X. That helps get this video out in front of more viewers. And what else? If you aren't subscribed on YouTube, what are you doing, kids? It's free. It's fun. We do all the things. Okay. I literally was laying in bed 5 minutes ago and threw on a shirt that I knew was clean and wobbled my way down here. So I'm like giving myself a pat on the back right now. How you guys doing today? Man, I'm kind of nervous about this. I don't know why. Oh, I didn't even explain the craziest part of this. So the judge sent the jurors back to deliberate yesterday. And immediately, the foreperson sends out a note saying that one of the jurors is refusing to deliberate and that he feels his way. No one can change his mind. I've never heard of this happening before. I don't know about you guys, but that's wild. You're there to deliberate. You're there to discuss the last 2 weeks together, right? Hi, Willa. And they brought the jury out and the judge read back one of their jury instructions about having an open mind and expressing your opinions with your fellow jurors so that you can come to a fair decision. Pardon me. I just took Flonase. So trying not to cough into the microphone. So the judge brought him back, read that, and the jury went back to the deliberation room and asked to leave 30 minutes later. They started deliberations at 9 a.m. this morning, and we don't know what's going on. A lot of people where I I've been looking think that this is a deadlock jury. Let me show. We got some live love going on with my Mod Mitchell. Mods, what's up? Thank you for everything that you do. I I recognize we have a low crowd right now, but honestly, I was supposed to be going live in like 39 minutes. So things are a little off. And Fridays are my slowest day. Oh no, someone's calling me. Hold on, guys. Okay. So I'm thinking that these counselors and oh, we got to show Willa because he's here. He always, if you have never been in my YouTube chat, he's always there. And he is always taking the side of the girl. And we love him for that. Like, he's just, like that's what you're going to get with him. And so with Corey Richens, he was pretty hard pressed that she was innocent. And we were all like, man, you're crazy. But we love and appreciate our viewers. I was in a jury where most didn't say anything, but at least they voted. That is wild. Okay. So that guy wants to know what case this is. And this is Josh Hutchings. Josh doesn't live too far away from this courthouse. And so he decided to drive and go watch a couple days. This is the Suzanne Mericle case. It's happening in Georgia. And she is being charged with several different offenses, including the untimely unaliving of her boyfriend, James Paul Barron. So we are waiting anxiously because yesterday a juror was refusing to deliberate. And after being reread their instructions, they all wanted to leave. This is going to be interesting. And I asked Josh, I was like, from your time in the courthouse, do you think you know which juror it was? And he said, absolutely, which is like, you just know. If you are someone that follows like court cases and you ever have the ability to go check one out in person, you always look at the jurors and you like, I don't want to say stack them up in your head, but you like assess them and try to get an idea of where their head is at. And he said, Willa said, I'm making pancakes. However, this woman is guilty. This is a monumental thing for Willa to say. He never says that about it. I've always joked, like, God forbid if I were being I had to go to court for something that was totally not true and I needed a jury, I would want Willa on my jury. So I see we have a few new jurors. I see we have a few new viewers. Hello. Please make sure to hit that heart button on X and the thumbs up button over on YouTube. We are live waiting for the verdict to be read in the Georgia versus Suzanne Mericle case. And as I've been explaining, I've been following this trial since day one. She is 61 years old. She was getting ready to sell her dental practice. She is a beloved sister to 7 siblings and a mom to 3 children. Oh, here we go. They don't have the volume on yet. Oh my God, guys. It's not me. It's the videographer. Or we're waiting for the volume to kick on. Dude, come on. Now I'm inevitably going to check and see if there's another stream, which that's dumb because they would probably be using the same video as well. Volstrom, you can't hear me? Can you guys hear me? Okay, all right. Holy crap, Volstorm. It's not funny. That happened to me yesterday. We can't hear the court. They haven't. Okay, thank you. Sorry. Here we go.
Thank you. Question from the jury. I think it's safe to say it's a two-parter. In order to find her guilty of criminal damage to property, we do not need to confirm her intent was to injure him, correct? We do need to agree her intent was to shoot the door and that a natural consequence of shooting the door caused his death, correct? My initial reaction is the first question is easier than the second question.
Not a verdict, just a question. That's okay. Hey, everyone just joining. Welcome.
That's what Anna just said.
So was this a question or a
I think the answer to the first question is yes. I think the answer to the second question and the proper thing to do is to recharge on criminal damage to property in the first degree.
As well as causation in felony cases, Judge. Felony murder.
They didn't ask a question about the felony murder.
Well, to me, the second part of the question is kind of combining felony murder. Because it says the natural consequence of the shooting of the door is what caused his death, which to me is going to the felony murder.
What kind of question is this?
Let's go one at a time. Any proposal on the first part of the question?
Yes.
Just simple yes.
Yeah. We do not need to so the question was, we do not need to confirm her intent was to injure him, correct? And I think we could just put yes or correct.
I actually wrote
Defense.
With respect to the first question?
With respect to, we do not need to confirm her intent was to injure him, correct? Question mark. Underline, not underline intent.
Correct.
Are you ready? So what I propose is we label it 1.
Gotcha.
And Mr. Preston, if you don't mind retyping the question, including the underlines, and then the response is correct. All right, catch up on that.
I'm trying to ear hustle on the attorneys.
Yeah, that's what it leaves out.
Yeah, I think so. Thanks for the 9er. Oh my God. I'm like, I don't know the Georgia law, so it's not like, apparently I did hear them say that one part, there are 2 parts, and there was intent, and that was the one that was left out. So, Josh, you've also been following this case. What do you think, what are your assumptions are?
So I think the second answer is probably.
So I think the second part of the answer is probably,
The intent is knowingly, without authority, endangering property in there. All 3. That's the intent. That's 3.
You good with that?
Yeah.
State's proposal on, we do, underline do, need to agree her intent was to shoot the door and that a natural consequence of shooting the door, parentheses,
sorry
or
guys, my mom's
brackets,
texting.
caused his death, close parentheses, correct, question mark.
Judge, we would propose that Your Honor bring them out and recharge them on criminal damage, felony murder, and the causation.
Josh is not in court.
Right.
Hold on a second.
Yeah, just the felony murder obviously adds to criminal damage.
I also expected a verdict either in the morning or at 4:00 because no one, there's like a statistic about people on trials.
26820, criminal damage to
In
property in the
Fridays.
first degree. I'm sorry, what else?
The felony murder charge as to criminal damage. as-
Page 8, is that correct?
Yes, let me triple check.
On page 8?
Yes, Your
Josh
Honor.
is in the other chat.
21020,
I'm really trying to ear hustle, guys. And there are
What
2
else?
conversations. going
I
on.
was trying to find it in the packet. Give me 1 second, Your Honor.
I didn't even take my meds. Sorry, guys. I gotta do
The
that.
causation and felony murder 21030 on page 9.
any other proposal?
That's it, Your Honor.
I have state's proposal 21020, felony murder, 21030, causation in felony murder. Page 11, 26820, criminal damage to property in the first degree. Defense.
Yes, sir. So this was part of our requested charges, was to tell the jury specifically that knowingly applies to each of the elements that follow it. So I think at this time, it'd be proper to give them that correct statement of law, that knowingly, that her intent must be to knowingly, without authority, knowingly interfere with property, and knowingly in a manner so as to endanger human life. Because they've asked very specifically for that, and it is correct. And to leave that out when they've asked the very specific question about intent and which of the elements it applies to would be a mistake. So our position is, and I think frankly, respectfully, I don't think the court has a whole lot of leeway with what they've asked for. They're asking for the intent. Does the knowingly, what does knowingly apply to? And it applies to all the elements, which would be knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life.
I'm not saying I'm necessarily going to give it or not give it. What was your request to charge number on that?
Give us just 1 second, Judge.
Willa Mackin in the chat. Sorry, I haven't been paying as close of attention as usual. I didn't put up a poll. I just crawled out of bed.
46. 46 maybe?
Yes.
Sorry, Jess. Thank you again for the niner. Roger. Towards my hashtag goals of living. Survival. I tried to play the lottery with you guys. Was not a lucky winner. Yeah. Survival goals. Apparently, having robotic surgery on your heart is not cheap. You got a scratcher today? Tell me all about it. I still have the scratchers that I got last month, just randomly trying to do like an engagement thing for the stream. I still have the cash explosions. A few of them. I thought I had more than 3.
Yeah, we object to the reading of this charge, Judge. This
I just.
charge has already been denied. There's a lot of stuff in here that they're not even asking about as far as the without authority and who has legal right and privilege to the door and like all these things. This
Cash
just goes way
explosions.
beyond even what their question is. I think it's perfectly proper for Your Honor to reread the instruction that's already been given to them. And not to now add a new charge they haven't heard yet that also includes information that they're not asking about.
I think if you leave out the last paragraphs, Judge, if you leave out the last 2 paragraphs of defendant's request 46, and you could even put knowingly without authority, knowingly interfered with property, and knowingly in a manner that endangers human life. In other words, it would just be set out. Instead of in 1, you'd put knowingly without authority, knowingly interfered with any property, knowingly in a manner that endangers human life. and that would get exactly the same thing. And you could even cut out the paragraph below that. They're asking about the intent, and that is the intent that's required. So I would say you can cut out everything below 4. You just put knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life. The defendant acted, I guess would be the word after the.
Okay, so let me give you guys like a debrief of what's going on. One of the charges is
Okay.
I don't think that.
May I approach this?
is literally a charge that she committed, she being Suzanne,
Can you show it to them?
committed a
Thank you.
like an assault against a door that led to the harm of someone else. They say that they use this same law or charge rather for drive-by shootings, and like if you're in the car, that you'll get charged with that. But in this case, it's a door from her own house. I just don't think the state really was strategic with their charges. I think that they threw the book at her, and there are probably some people sitting on the jury that have been wronged by the judicial system, and they're looking at this as like the system trying to railroad her. I don't know. That is my perception of this. I'm absolutely open to hearing what you guys think. I don't hear them whispering right now. Do you guys have any questions? I'm going to let everything else in the chat, like, you guys do your thing.
State.
Judge, I don't think that we should be charging them on anything other than we've already charged them on, and reread the charge as pattern that we've already read for criminal damage, felony murder, and causation of felony murder. I think it would be improper to start adding things to a charge. Your Honor's already declined defense's request to charge, and
I don't understand
think
what
that
the
it's
door did
proper to
either.
now change the charge that they already have. I
was
believe
locked.
that what we've charged them on is pattern. It's the appropriate law, and that would be the appropriate response to their question.
And the appropriate response to the question is the correct statement of law on the exact issue that they've requested.
Which is the pattern. Right.
No, they've asked specifically about the intent. Does it apply, and what does it apply to? And it's correct to tell them that.
What was the intention of
And
this
to leave it
door
out,
assault?
and they don't know knowingly applies to the conscious disregard. And that's the gravamen of the offense.
Yeah, there's no conscious disregard.
Well, to the whatever, to the last element. And knowingly endangering human life.
The door was locked. That's what the door did wrong.
Yeah, I mean, the correct statement of the law is the statute. We shouldn't be adding words to the statute. The statute is the correct statement of the law. The statute is what the pattern charges and what we've already charged them on. It's not an incorrect statement of the law to charge them on the statute.
They've asked.
Well,
You can-
hold on. I'm certainly going to charge them on page 11, 26820. I mean, that's going to happen. So, I mean, that's,
So
so hold on. So the only question is, with their specific question, do we go a little bit further? And here's where, I mean, on the first one, it's correct. On the second one, we're not going to tell you whether it's correct or incorrect. We're just going to read you again, which may very likely be what happens, and that's fine.
And so how?
I mean, they're partially right, partially wrong. I mean, yeah, kinda. I mean,
How about we charge them also on intent? If their question is about intent, there's literally a pattern jury charge on intent, 14110. We charge them on the pattern jury charge of intent so that they know that criminal intent does not mean an intent to violate the law, but means simply the intent to commit the act. It also talks about how intent is an essential element of any crime. It must be proved by the state beyond a reasonable doubt. Like it covers all of that as far as intent. And then charging them on the statutes for the two crimes that they're asking for. That is all correct statement of the law, and it's a direct to their question.
They're only asking about intent as to one charge. They only have a question about that. And they specifically put in their question, we do need to agree her intent was to shoot the door, and then they make a mistake and they say a natural consequence of shooting the door. That's incorrect. And then they put in parentheses, endangered human life. Her intent has to be to knowingly endanger human life. That's the correct answer. That's why we have to tell them that. We don't just go, well, intent generally is this. They're asking about this charge. The intent is knowingly endanger human life, period, in the story.
Yeah.
go ahead.
I think that's a complete misstatement of the law.
Which part? The knowingly part?
The knowingly endangering human life. She has to knowingly commit an act, which in turn endangers a human life. She has to knowingly commit the act, which is shooting at the door.
Hold on. Let me run this by Alan. I'm not saying I'm going to give it. For the charge of criminal damage to property in the first degree, the state must prove beyond a reasonable doubt that the defendant knowingly interfered with the door without authority in a manner that endangered human life. Knowingly means she was aware of her conduct. It does not require proof that she specifically intended to damage the door for its own sake, or she intended to injure the victim.
I
don't think that's correct.
Yeah,
Okay, that's fine.
I think the knowingly is.
So here's where we get into it, because it's not quite correct. And if we're just going to read what they already have, I mean, they have a copy of this back with them.
The shortest answer.
Without answering their question.
And they've asked specifically just about the intent about criminal damage, and specifically with respect to endangering human life. The correct answer, the answer that is clearly the correct one, is they have to prove that she knowingly endangered human life.
That is incorrect.
I think
That is incorrect.
they have all shot a door
Go ahead.
on that
The
jury.
rule started in the United States Supreme Court with the Flores-Figueroa case, which was extended into our Scott case that we put into our brief. When the word knowingly is put in a statute, it applies to every subsequent element of the offense. That was the trafficking statute that struck down the trafficking statute about whether knowingly applied to the weight.
But look at
And our Georgia Supreme Court, following the U.S. Supreme Court, said, when you see knowingly at the beginning of a statute, it applies to all the subsequent elements. And they're asking specifically, they're saying, hey, what is the intent? Is it just that it's a natural consequence? But then they put parenthesis, endangered human life. They're asking, does knowingly mean knowingly endangered human life? Because that is the element that has to be proven by the state beyond a reasonable doubt. It's the correct answer to tell them knowingly endanger human life. There is no argument to the contrary that's correct. This is the law. Knowingly endanger human life.
I am
Period.
the law.
All right, state.
Judge, that's incorrect. The element is interfered with any property in a manner that endangers human life. He's separating elements. You don't have to knowingly endanger human life. The intent is committing the act. The intent in this crime is you have to intend to commit the act. That act endangered human life. It is that she knowingly and without authority interfere with property in a manner that endangered human life. She has to knowingly interfere with that property, and in doing that act, endanger human life. He is incorrectly stating the law. My computer's not working. I'm trying to pull it up.
Oh,
But
man.
the knowingly does not apply to in a manner so as to endanger human life. That is an incorrect statement of the law. That is why that would be incorrect to add that into the pattern. He's separating one element into two and adding knowingly where there shouldn't be one. There is an intent to knowingly commit the crime. She has to knowingly commit the crime, not knowingly endanger the human life. He is misstating the law. That's why I propose reading the statute and the pattern as charged, because that is a correct statement of the law, instead of adding the word knowingly in front of lines where it doesn't apply.
I wasn't reading
And
chat, and now I came
The
back to
reason it's
chat.
knowingly, in addition to the fact that that is the law, is because she has to knowingly be endangering human life. That's the scienter. This is the gravamen of the offense.
This is the way
Knowingly
we talk.
endangering human life. She can't unknowingly endanger human life and be guilty of criminal damage first.
Oh,
That's not the
shoot.
crime. Crime is knowingly endangering human life. Doesn't mean she has to
Hold
intend
please.
to take a life, but she has to knowingly be endangering it. It is a criminal negligence offense, in essence, knowingly endangering human life.
Oh my God, I hate myself.
They've asked specifically, and they're conflating natural consequence of the act with what the actual element is, which is knowingly endangering human life.
Okay. Give me a second, please.
I forgot to set up this stream so that I would get monetized. And so you guys, I've just been working for free other than the $9 that Jess nicely sent. Stupid StreamYard. Hey guys, make sure to hit the thumbs up on YouTube and the heart on X. Let me know if you're enjoying this, if you're watching on X, because I haven't been doing X for the last 3 months. I wanted to build my channel outside of it. And I want to know if you guys are enjoying it, if I should keep doing it. Okay. I don't have time to figure this out, but it sounds interesting. Carry on. That's all we do. Can we carry on? Can you restart? I have no idea how it works. Restart what? Did something go wrong on my side? Mods, you should mod wherever you feel most comfortable. I am actually, that's what I was getting ready to say earlier. I wrote out something that I need to send to my Discord mods, or to my mods in Discord, about removing wrenches, because as you guys saw at the beginning of the show today, it was all blue, and that was me giving away wrenches when my top mod had to take a step back, and she wanted to try to teach people what she was doing to help me with my channel. And in that panic, I gave away a lot of wrenches, and cool people, no problems. I still want them to watch, but for the time being, I got to get the sea of blue out so that we can have regular viewership, if that makes sense. And I wrote it out very diplomatically. It is not a personal, this isn't a personal thing. And I don't know who I'm taking out yet, but people like Mitchell and Kristen, no, they're here every stream.
All right. Well, is your computer up to speed?
What I've been kind of, it's grazing off and on. The case law I found, Judge, basically says that, like the one that I was trying to read right now before it froze, was saying that the knowingly as part of endangering human life for the criminal damage means reckless endangerment rather than actual endangerment. So like you can commit criminal damage to property when no one's even in the building and you shoot into an uninhabited building. And so it's more so you're knowingly committing an act that could endanger human life. And I've also seen examples of arson where arson also includes the language knowingly, and it had the same exact, basically it's more of a reckless than it is an intent to injure or an intent to endanger human life.
All right, so let me interrupt, and we'll talk about this a little bit further. Is there a point in bringing them back and me rereading what they already have back there? Or do we say, look at page 6, page 8, page 9, page 11?
I think you just.
I mean,
give
that's
up.
fine. I think it gets the same effect across.
I think there is. I think we have to answer the second question with a correct answer. I think the correct way to deal with it respectfully, may I remain seated?
Yes.
Would be to answer your first question. We do not need to confirm her.
So the answer to the first question, we do not,
I do declare.
the response is correct. And so
Yes.
I've already written up, and I intend to send it back to them, is we will address question 2 in court, which we can do, or I can change it and say,
I think-
read these 4 charges in this order.
I don't,
And I understand you disagree with that.
yes, sir. I think that we have to answer both the questions for them correctly. And I think the answer to the first question is yes, but to then not include the answer to the second question is highly confusing to them. The answer to the second question is, we do not need to agree her intent was to, we do need to agree her intent was to shoot the door. They're just talking about the act. And that a natural consequence of shooting the door caused his death. Not correct. Not correct. We do need to agree that her intent was to knowingly interfere with the door and knowingly do so in a manner that endangers human life.
This is over a door.
That's the correct answer to the exact question that they've given. And I don't think that we should split up the answers because they're asking all around the criminal damage intent. The correct way to do it would be, the answer first one is yes. The answer to the second question is, we do need to agree her intent was to shoot the door and that she did so knowingly, without authority, and knowingly within a manner that endangers human life.
And Judge, many times the correct answer is just to read them the appropriate charge.
Oh, are you a judge?
I agree that in a large percentage, I do have concerns that they've narrowed in on a very narrow issue. So I mean, my initial inclination is just to either reread or point out charges to them and see if they have any follow-up on it. That's my initial reaction. However, I do find somewhat compelling defense's argument to try to be as specific as possible with the correct statement of law. And I understand that the parties disagree on what the correct statement of law is or is not. So do you need more time on anything?
No, Judge, just that I'm just continuing to read cases that all say the same thing as far as the endangerment of human life, that the courts consider it more of a reckless endangerment than anything else, because you can commit the offense of criminal damage in the first degree by shooting into an uninhabited building. And so again, it's just, you're knowingly committing an act that whether or not it actually does endanger human life, it's basically reckless to do so because it could endanger human life, is what all these cases are saying, which is why the state's argument is that to put in there that you have to knowingly endanger human life is an incorrect statement of the law, because you don't necessarily have to actually endanger human life. You just have to knowingly commit an act that is basically reckless endangerment, because your act could carry with it the possibility of endangering human life. That's why state's position is that Mr. Willis's statement of the law is incorrect. And I was looking specifically at 272 Georgia 378, which is a Georgia Supreme Court case, Carthern v. State. Oh, okay.
Defense, you had something?
Just going to restate
could
that. I
have said
think you
something
tell
to
them,
Mama
answer
right
your
there.
first question and then state the question is yes. Answer the second question. We do need to agree her intent was to shoot the door and that a natural consequence of shooting the door causes death, correct? That is not correct. You need to agree that her intent was to shoot the door and that she did so knowingly and without authority and knowingly in a manner that endangered human life.
That's the point. That's aggravated assault. I mean, it's just an incorrect statement of the law.
That's
Every single case I've read on criminal damage to property over and over says it's a reckless endangerment, not an intentional endangerment. You don't have to knowingly endanger human life. You knowingly commit an act that could endanger human life, and so your act is essentially reckless. You can shoot into an empty building, not a single
Let me
person's
interrupt.
in
So
there.
what we're going to do is I'm going to direct them to reread certain parts. I'm not going to invite a question. If they have a question, essentially, Judge, that's not what we asked you, then we'll see where we go from there. So defendant's specific request is denied. Any preference of order or just say, look on these pages with this number?
Just chronological order of pages is fine, I think, makes the most sense.
We're saying yes.
Yeah, he's saying correct
Yes.
for the first one, and then the pages for the second one.
So it will be something along the lines of this. Question 2, please look on page 6, 1.41.11, no presumption of criminal intent. Return. Same verbiage. Please look on page 8, 2.1020, felony murder. Same verbiage. Please look on page 9, 21030, causation in felony murder. Same verbiage. Look on page 11, 26820, criminal damage to property in the first degree. That's our first step over defendant's objection. I'll take inquiry on that. I'll allow defense to preserve their record if they need to.
I'll do so after the charge of the court. Thank you.
Keep commenting, you guys. I have like a queue of things I need to address. First thing, Mama, the reason I do that is because YouTube started a different viewing experience, and I was it feels like one of the first people to jump on this this viewing experience, which is vertical, and because of that, it's treated me really, really good and helped me elevate my stream views like exponentially. Last night I had 14,000 views.
For
Most of that is
scheduling
through vertical.
purposes, I will go as long as the jury wants to go today.
Yes, Your Honor.
For, and I'm not blaming anyone, but for sheriff department, et cetera, we will not have court on Saturday. So if this goes past today, it will be on Monday.
Yes, Your Honor.
Is the defense attorney pissed? He's really sick. That's the other thing. Nikki. Oh, you're so sweet. God bless. Thank you. Yeah, I haven't seen a Saturday trial since like Casey Anthony, right? So what I can is Josh still in here? Because or attorney?
Yeah.
Because what I get from that is that it's very specific to Georgia statute. And my takeaway was that the
Thank
state
you.
won that argument. But I don't necessarily believe that
No objection, Judge.
the state
Same objection.
Same objection is noted for the defense. This question will be labeled C7, Court 7, and will be given to the court reporter in a moment. I will send a copy back of their question so they know what it was, just in case they might have forgotten.
here, Mama, I'll put my if you're talking about streams, I will put my YouTube channel here in the chat. There you go. If you aren't a subscriber, but if you go to my channel and you hit the tab that says live, it'll show you in
I'm
like
going to do basically a duplicate original of C8, which is signed and dated by me.
in the order of the most recent videos to the oldest.
Madam Court Reporter, C7, C8, please. Thank you.
Oh, that's what she was referring to. Okay. All right. All right. Yeah, doing court on Saturday does make sense when there's sequestration. Now, it was interesting in the Casey Anthony case, which was several years ago, but I covered it back in December. You don't realize how much goes into making a courthouse available for jurors on a holiday. In this case, it was Memorial Day and on a Saturday. You have to think about the lunch accommodations, the transportation, the security.
Anything else from the state?
Security
No, Your
outside of
Honor.
Anything else from the defense?
No, sir.
Chief Bailiff, I'm going to hand you a copy of their
the
question.
sheriffs and transportation for
And
the
then I'm going to hand you a
defendant.
copy of the court's response. Thank you.
the Casey Anthony
And
jurors had
at
the
this time,
greatest
since we're sending the
sequestration ever.
response back, I guess I'll just restate our objection officially to the charge in response to the juror's note. We're renewing our previous. I'm sorry? Yes, okay, but just a second.
Yes.
We're just renewing our objection and requesting states.
You can go ahead and take that back. Thank you. Go ahead.
For
We're
like,
renewing our objection to the
appeals.
states, to the court's response to the jury's note, and asking for a ruling on our objection to the court's response to our objection.
Meaning your proposal.
we have
Yes.
168.
Okay, to be clear,
people
that
watching.
proposal is denied
Total.
for legal purposes.
Thank you.
All right. Anything else?
Those are-
No, Your Honor.
Okay. No comment one way or the other. Don't go super far just in case they review it and go write another note. But I'm going to step off the bench and they may not respond or they may respond immediately. All right.
Your Honor.
Thank you.
Okay. Yeah, so defense probably has court on Monday, so this would be a tremendous pain for the jurors to let me turn this down. And while I'm thinking about it, actually, I'll mute it as long as we can keep it on the screen. So first and foremost, I know I'm kind of jumping around, but there's a lot going on. I did not get a notification that something was happening. By the grace of baby Jesus himself, I happened to click over on my phone to the Verdict Watch stream with Law and Crime. And I was like, oh my God, they're all back in there. And I saw the chat going crazy and ran into my creator room and just started setting up. So things were done very brashly. In doing so, I did not set up monetization, but I corrected that issue. Please know, if you do want to support this channel or the stream or my I'm not going to say if you want to support myself, because that sounds like a OnlyFans situation. If you are interested in that, I do memberships on YouTube for $6.99 a month. You get your own emojis, you get your own chance to have your comments highlighted, and members only streams and several other things. If you are interested in supporting in another way, we can do Venmo, Cash App, and Super Chats. But I want to make sure everyone knows that all donations now until May are going towards my heart operation. So it is towards surgical expenses and being able to continue doing this while I'm going through that for my situation. And up on the right-hand corner of the screen, you should be able to see. If you can't, let me know. There's 2 QR codes. One's for Venmo and one's for Cash App. But on the bottom ticker at the bottom of the screen is that information as well. Okay, now that we have that out of the way, please remember to like, whether you are on X, or give it a thumbs up on YouTube, subscribe because it's free. And I do 2 streams. I do one vertical stream and one horizontal stream. So I do that for their own individual purposes. I've been working with someone trying to get my YouTube a little boosted up by telling me like what I need to change to get the algorithm to like me again. And she's donating her time out of the kindness of her heart. So yes, what's the most helpful way to share your stream? Through social media. So if you want to just like reshare it on X or YouTube or Facebook or Instagram, please, by all means, do that. That helps greatly. And this case, let's get back to that. This case has been wild. Suzanne Mericle is a now 62-year-old woman who has spent her entire life being a mom and raising her kids while running an incredible dental practice in a very prestigious area of Georgia called St. Simon's Island. She was looking for love, ended up back together with an ex-boyfriend, and things this time moved really fast. I'm going to do my hair while I'm talking about this. And I am going to put something on the screen reminding people to like, share, and become a member. Okay. So she started dating this guy back in like 2024, earlier in the year. And just things moved really fast. And she was very clearly is someone who requires a lot like very high maintenance, very, very needy. And it is my absolute opinion, not as a medical professional, she displays severe symptoms of borderline personality disorder. If you don't know what that is, it is a personality disorder. You can't get rid of it, but you can gain the skills and skills and pills, baby. Like, talk about that in therapy all the time. That is, you okay there, bud? Um, Something that helps a lot of people who have BPD. Not me. I'm just sharing what I know. And one of the things with BPD is like, I hate you. I hate you. Oh, don't leave me. It's very manipulative. It's gaslighting. It's really putting people into horrific situations. So I don't think this guy knew what he was getting in for. And I think by the time that he realized what he situation he was in, he was like, it was going to be really difficult to part ways. And they had decided to buy a house together. And by house, I mean an extravagant lakeside condo. And the mortgage a month was $9,000. There is a lot of he said, she said when it comes to the expenses and like what was put down. And apparently he wanted the house to be in his name for tax purposes. She also wanted it in her name for tax purposes. So they were both on the mortgage together, but they were not married. That was being discussed. She would ask him almost every single day if he was going to propose, and it was really awkward to read those messages. Come to find out, after they bought this beautiful home together in October of 2024, in December, they are on their way to a furniture store, and she grabs his phone to put in the directions for the furniture store, and a text message pops up. And he immediately grabs the phone away. And girls, like, if your man ever does that, or dudes, if your girl ever does that, and they are not planning a surprise birthday party for you, there's a third person in your marriage. And unfortunately, she at this point finds out that her boyfriend, James, what's his last name? Starts with a B. I keep wanting to say Burrow, but that's not it. James, he decides to let her know the truth, which is that he has been sending two women, a woman and a daughter, $3,500 a month and they live in Romania, with the intention of helping them get a green card. And he says that they had gone on a vacation together to Croatia years before, or he had met her then. And, when Suzanne found out about this, she was devastated. And one of the reasons, there are many to be devastated in this situation, but one of the reasons is because he was having issues paying like an upfront cost for the home, putting down a cash payment. They had originally agreed on each of them, like putting down, I think, $300,000, and he only put down $100,000. And he was asking for her to cover her the month that he passed away. And once again, that's $9,000. That's a lot. So the mother and the daughter continue to remain a very hot topic to Suzanne. She literally cannot let it go. Things are fine. Like, they'll be having a fine day and she'll just completely be like, why don't you love me? Why do you still talk to this woman? Just absolute ludicrous stuff. And I think towards, after the holidays, they had the family there at their new condo, and there were interventions between December and March with the boyfriend, James. And these interventions were because of this woman he was sending money to, which could be money not only going into his mortgage, but towards his grandchildren's education expenses, like what normal wealthy grandparents do. And he was wealthy. He owned a company that basically does like they create what a airport looks like on the inside and out. And so offices all around the country, and very successful. This would have been his third marriage. Suzanne and her sister somehow get this woman's information, address, phone number, find them on Instagram. Suzanne starts counting the amount of men that she follows on Instagram and Facebook. And I mean, girlfriend needs to talk to somebody, right? Enough's enough. And I don't think that Suzanne's sister was as successful as she made it seem when she testified this week, that she was getting through to Suzanne, that Suzanne was ready to leave them. But, I'm trying not to skip over things. But when Suzanne's family met him, they were not crazy about him. And then they found out about the woman in Romania, and they became even more not crazy with him. And the other part of that is that his family loved Suzanne. And so they feel a tremendous amount of guilt for encouraging their dad to be with this woman when she ultimately led to his demise. And during these couple of months, these arguments would just keep coming up. And she had told her sister that he was violent. And it had concerned her sister so much that on the day that the awful event took place with the door that you guys just heard so much about, this is killing me. On that day, I think her name is Dana. Dana, who is Suzanne's sister, called the police, and we listened to the 911 call and asked for a welfare check for her sister because she had been trying to get a hold of her sister all day. Her sister lived with her phone. She had like kind of threatened to call her sister's kids, and still no response. In the 911 call, Dana says, I'm worried because this man has like a violent streak, a mean streak, something along those lines. I just got to take this out. And she ends up giving her information and has no idea that her sister is literally in questioning at the police department for murdering her boyfriend. Now, how did the murder happen? It was March 7th, 2025, so only a year ago. Things, I guess, move much faster in Georgia than I would have anticipated. That stuff in Ohio takes forever. So they're in their condo. They had a nice day. Their nice day consisted of going to the Olive Garden after going to the BMV to get her temporary license because she had gotten a DUI the month before. On February 27th, February 16th, 2025, Suzanne and James got into yet another one of their magnificent arguments, and Suzanne fled the house. She says that he tried to sodomize her, and all the bad YouTube words. Yeah, I'm like purging views on YouTube right now. And she tries to leave, and she changes on the side of the road because things were moving fast. She grabbed her keys, her phone, and left. Gets pulled over, gets a DUI, and so that leads to March 7th and her having to get a breathalyzer thing in her car so that she can start the engine, and a temporary license. And it was yesterday we found out that he half the time was blowing into the thing for her, the breathalyzer. If the chat wants to give me the name of that device, is it interlock system? Am I right about that? But yeah, you basically have to breathe into it in order for your car to start. And that's awful. But they had a nice day, and then once again this Romanian woman comes up. And the Romanian woman that he is still sending money to, even when he's asking for Suzanne to cover his side of the mortgage that month. I would be irate. First of all, I would not be living with a man who was sending money to women in Europe and agreeing to help them with a green card. Like, are you kidding me right now? Tell me in the chat, would you guys be okay with that? Like, am I crazy for saying that? And this argument keeps going on and on and on. And James allegedly grabs her by the hair, makes her do things in I can't say these words, perform acts that she does not want to perform. And when it's all said and done, he says something along the lines of, if I were you, I wouldn't close your eyes tonight. And grabs his gun and goes upstairs. And so Suzanne is like, why are you grabbing your gun? And he says, to protect myself from predators. This is at like 11 o'clock at night. And some time goes by, but when she hears him say that, she goes, well, James, I have a gun too. And she goes and gets her Beretta. And through a very wild series of events, he ends up locking himself in the master bedroom with her phone and the keys to the only working car that the couple has that weekend. And she is adamant that she wants to leave. And she needs the keys and she needs her phone. So she is knocking, saying, "You open this door right now. I need to leave. You have my phone. You have my keys." Oh, I forgot what happened right before this, which caused the assault to happen. Apparently, in a very BPD way of getting back at him for the Romanian girls, she decides to start talking to this guy named Charlie English. And they're like sexting. And he discovers these texts on her phone. And she was like, "Well, you have your Romanian whores, and I I until you stop talking to them, I'm not going to stop talking to Charlie English." I mean, it's sad that Mr. English had to be a pawn in a very messed up situation, but it is what it is. So he takes her phone, probably to go through it and to go to bed. And we don't know his side of the story because he ends up dead. But he's in this room behind this locked door, this door that you've heard so much about. And she, after asking him several times to unlock the door, she tells him, "I'm going to shoot this lock off the door." And I mean, everyone is probably thinking to themselves, as we did watching this trial happen, why not just get a Phillips flathead, like a screwdriver? Or why not try to pick the lock? And on the stand, Suzanne basically says, "I didn't think of that." And all the, like, she was just intent on shooting the lock off this door, which now is causing her far more problems than I think she could have ever imagined. I, for 1 second, do not believe that that woman walked upstairs to kill that man. I think that woman was full of angry, hate-filled rage and wanted to prove her dominance, her control over the situation. And like I said, this is not unbiased, this part right here. This is, I truly believe what I'm saying. After watching what I've watched and knowing the people that I've known in my life and seeing other ridiculously similar situations happen. Not a door, but she finally decides that she is going to shoot this lock off the door, and the bullet enters her boyfriend. Like the worst luck ever. But all evidence shows that no one's in dispute that she shot 6 inches away from the door at the lock. And the state is saying that she knew he was in there laying in the bed, and that she essentially shot in the direction of the bed to shoot and kill him. And apparently 2 rounds went off. She said that it was very quick in succession. What is so difficult for the mind to grasp at this point is why she did what she did next, which was grab the cartridges in the live ammunition and flush it down the toilet. But this is after feeling for a radial pulse and saying that she was unsuccessful in finding a pulse. She called 911 like 6 times. And do you guys want to hear the 911 call? I won't make you guys listen to the whole thing, but do you guys joining me today, do you want to hear a snippet of what I'm talking about to get an idea? I haven't been looking at the chat. I've been trying to get through this story, but I don't want to leave any parts out. Let me know if you want to hear the 911 call. Okay. Hold, please. The first thing that came up was Suzanne Mericle body cam. No. If guys, it was bad. It was bad. Okay. I will turn this on and begin.
I'm Deputy Zachary H. Martin, currently employed with the Hall County Sheriff's.
Tender and play the 911 call as states Exhibit 1. We had previously submitted a business record certification and notification to the defense of the 911 call.
No objection to States 1.
States 1 is admitted without objection.
We could have just one moment, Judge.
Okay, here we go. You guys asked for it. Don't say I didn't warn you.
Hall County 911, what is the address of your emergency?
Oh my God, I need help.
What's going on?
I need help.
Keep in mind, she's
What is
a
going
doctor.
on?
Please help me. Please help
Where are
me.
you at?
I'm at,
Where are you?
I'm at 4,
You're at a barn?
2, 3, 8, Mavis Drive.
Okay. What's your name? All right, tell me exactly what's happened.
What?
What? Tell me exactly what's happened. Hello?
And you know this lady's singing, oh, we got another drunk one, Jerry. Online too.
Hello? Can you hear me?
I'm not laughing at it.
What's going on? Hello?
Yeah, I am laughing at him. That's the emergency.
County 911, what's the address of the emergency?
I have an emergency.
Yeah, you do.
He's dead.
What's going on?
I need help.
What is happening?
Oh,
Oh my God. Oh, baby.
dang it, I lost my
Can you tell
buzz.
me what's going on?
What?
Can you tell me what happened?
I can't hear you. What?
Can you tell me what happened?
No, I just need some help.
Okay, what's wrong?
He's dead. Oh my God. There's blood.
Hey, mods, if I get Jules, please let me know.
Okay, and who is it?
He needs help. I can't feel a pulse. Please get the ambulance. Oh my God.
Can you tell me your address?
Oh my God. Oh my God. Oh my God. 4, 2, 3, 8.
10-4.
Wait.
4238. Okay, I need to know what happened, okay?
She is 61 when this
I need
happened.
it, okay. Can you tell me what happened?
Kylie. We're waiting.
We've already got one on the way, okay? I need to know what happened. He's still alive? Okay, we've got help. Hey, I need some officers outside.
Oh my God! Oh my! Oh my God!
I have that going on my other screen.
Okay, are you able to go to your front door?
Judge is not back on the bench. Has she seen an alien?
Can you hear me?
So very good question. I think that what she told her therapist was that she panicked and just flushed them. Pure and simple. And all this blood is coming out. And she's grabbing towels, trying to push it like back towards him. But she's a doctor. Like, I don't care if she's a dentist. You still have general medical knowledge. All right, I'm gonna grab another, and when I come back, we're turning this off.
Polk County Dispatch, how may I?
Have you had the opportunity to review the incident detail report or CAD report from EMS on this case?
Yes.
And can you tell the jury what time the first call was placed?
The initial call came in at 1:11 a.m.
Okay. And what time did the caller hang up on the first call?
The initial call ended at 1:13 a.m.
Okay. And then what time was the second call placed?
The second call came in at 1:13 and it disconnected at 1:13. The span between the first call, the second call, and the second call ending was roughly 30 seconds.
Okay. And then what about the last call?
The third call came in at 1:19 a.m.
Okay. And so what time did you arrive there at 4238 Bay Bridge Drive?
It was between 1:19 a.m. and 1:22 a.m. I don't remember exactly what time I arrived there.
Okay. And was anyone waiting at the door or outside on the steps for you?
No.
What did you see when you first arrived there?
So arriving on scene at the house, we could clearly see that there was a hole going through one of the windows upstairs. We could see that something had busted through one of the panels of one of the windows. All the lights inside the residence were on.
And so
Okay,
what
let
did
me
you
turn
do?
this off.
So as Deputy Thomas approached the
And so that's the 911 call. And like I said, she began panicking. And that is why she says that she flushed the bullets down the toilet. And they were later found in her septic line. Now, when the EMS guys got there, they found a pulse. I think it was very weak, and I don't think he lived, or I don't think he, lived much longer. But I think that she could have been providing life-saving measures. But I also know at the same time, and if you're watching, it might be because you are also a trial watcher slash someone interested in the genre of true crime. But I know that trauma impacts everyone differently. And I think what you just saw, for many of you in the chat, you're feeling the same guttural reactions that I felt. Like, my anxiety went through the roof just listening to that call. And it's I mean, I am just like, this has just been a crazy case to follow. Now, immediately, she is taken out of the home by the police, and EMS begins to work on him, and she just, for about 40 minutes, I know Mitchell was watching it live with me, but, and Nikki, I don't know why it took so long to get her secured and away from the scene. And quite frankly, I think she should have absolutely been sectioned and taken to a hospital. What you heard over that phone call, she exhibited in real life. Whether you think it's fake or not, it doesn't matter, because it takes the same amount of energy. And like, girlfriend looked like she was about to stroke out any second. She was flopping on the ground. She was like dry heaving. She was fake fainting. I think it was fake. If you're really fainting, your body isn't gonna hold out for you. She did make the call. But one of the things that the state was saying is that, like, they think that she could have shot him and waited for him to, like, be in really bad shape before calling 911. I absolutely do not believe that to be the case, because of the cell phone data that showed the phones going up the stairs at the same time. Like she said, he took her phone because he was mad about these text messages. And I don't know, just stupid, petty relationship argument about not giving her phone back. Like, they were in a very toxic relationship. I'm reading some of the chat. I haven't been reading any of the chat. I'm sorry. And I know I said this before, but if you are on vertical stream mods and someone sends jewels, please let me know. I keep forgetting to thank people because I'm not looking at that screen. He should be telling her to breathe, and it's okay. She's obviously hyperventilating. Yeah. I don't think I've ever heard of someone flashing bullets. That's a new one for me. Me neither. Hey guys, just a quick reminder. If you haven't done so already on YouTube, please make sure to hit the thumbs up button. Make sure that you are following me. If this goes past today, we're going to come back on Monday. I don't normally do Monday shows. I just do my show Tuesdays through Fridays, beginning anywhere from 3:30 to 4:30. So hit the notification bell on my channel page and select all so that you get a notification when I go live. And with that being said, one thing I was mentioning earlier, and then we'll come back to that night. There is statistical evidence that when a jury is deliberating on a Friday, verdicts tend to come back so much more than not, because the jurors don't want to come back on Monday. Like, they're just sick of it. They want to put the whole thing behind them. Toxicity and stupidity are not a defense for negligence that resulted in death. Okay, so here's the thing. My job here, if you haven't watched me before, I ask not only the extremely uncomfortable questions, but my job, like in real life, for the majority of my life, was to be a professional devil's advocate and to find loopholes. I'll just say it. Like, my nickname is Loophole Lacey. So I can sniff out certain things that I think the defense is going to stick behind, and we call that reasonable doubt when it comes to these sort of situations. And I don't want anyone to come into my stream and feel like expressing their opinion is going to be bad for them. I want everyone to be able to have their own opinions. But if you try to demean or talk shitty to someone who's just expressing their opinions, like, that's not cool in here. So I am a free speech absolutist. At the same time, I expect civility and just not being a douche. And that's not towards anyone, but it's because I see I have a bunch of people in here. And this is it's a highly contested, debated topic about what went down. She got onto the stand and she admitted that she had lied so many times throughout their relationship, throughout her incarceration. And that kind of reminds me of what happened after she was finally sent to a police station. So she goes to the police station and she does like the number one thing you're taught not to do. She starts talking to the police without a lawyer present. And I'm a firm believer in that. I'm also, I have had great experiences with police, but I know that there are situations like these, like criminal law. I don't know certain caveats, certain parts of how charging works, and I leave that to someone that I would pay a lot of money to represent me, to make sure I don't get myself into a predicament. And she just signs over her rights. Her attorney said, now granted, her attorney said this, so he's probably being very flamboyant when he refers to this, but he said that they just slid a paper over and said, for like formality purposes, that she needed to sign the paper in order to talk to her. She was waiving over her rights. Like, guys, and watch, more times than not, people just go ahead and talk to the police because they trust the police. And that's like, I do. I live in a great area. I have great police where I live. I think it's for my protection and for, you know, other people's protection. If I were to find myself in that sort of situation, which I won't, but I would make sure to have an attorney present and not just start spilling the beans to everyone. I don't know. Okay, I'm coming back over this. When was this sent? 4:39. Oh no, I just went through the case like top to bottom. I spoke like Drew Barrymore just now with your inflections. Really? I don't know how Drew Barrymore speaks. I actually find her quite annoying. Yes. And I am a very proud American. Did the police find his gun? Yes, they did. They did? You thought I was part of Drew's organization. No. When I was a child, I used to look very much like Drew Barrymore. It's very weird. Oh, well, thank you for the jewel, JB2. New subscriber. Thank you. Thank you. Yes, the police found the gun with him. Okay, not all cops are bad, but they would all break their oath to the Constitution if ordered to just keep that $46,000 a year salary. I don't even think it's the $46,000 a year salary. I think it's the pension. They have a great thing and they deserve it. They're keeping us safe. So I come at it from a very different perspective, but I also call out bad policing. So I'm a very awkward channel in the sense I support the blue, but I support officers who are doing their jobs fairly and correctly. And I absolutely believe in calling out the bad actors to ensure that it doesn't happen again. Okay, so the court case that we are referring to is Georgia v. Suzanne Mericle, but Miracle is spelled like French. It's Mericle. Mirceli, I think I would pronounce it if I didn't know. And she shot a freedom. What do people say on YouTube? She shot a gun. There, YouTube. Yeah. My numbers drop whenever I say a bad word. So she shot into a locked door in a fit of rage. And the state of Georgia is saying that she intentionally tried to unalive her boyfriend. I don't. How does someone behind a closed locked door know that they are going to shoot that person in the flank and cause them to get like a hemothorax and pass away? I sound like Reese Witherspoon. Oh, I'm sorry. Is someone asking questions about how the stream works? There are two streams. If you are on a stream that you don't like, if you're on the vertical stream, you can just click on my face. I think it's in the bottom right hand corner, or no, the top left hand corner of your screen, and that should take you to my channel. And the very first two things that come up when you go to my channel. It should be the live that I'm doing right now. One of them is a vertical for your phone, and one of them is a horizontal for your TV or for your laptop. This. I don't know what's going on in Massachusetts, and I feel so blessed to live in a state. Okay, Afro Man that's a whole different thing. I don't think that all of our police officers are like Adams County police in my state. That is just embarrassing. Great job to think for yourself. To think for yourself, real purpose, true American, think and add to the lexicon of thinking for yourself. So I admire that. Yeah, I don't like people who depend on other people for their opinions. I am like personally insulted and revolted by that. I think it's important to take in all of the information that you get and make your own opinions. Okay, good. La Lynn figured out how to do it. So let me pull up the charges. Suzanne Mericle charges. I'm telling you, that's how it looks like it should be pronounced. Okay, so hold on. Oh no. So she is charged with malice murder, felony murder, aggravated assault, and possession of a firearm during the commission of a crime. The malice, I feel very strongly about, was not proven. I don't think she walked upstairs with that gun to kill him. I think she was pissed. She wanted to prove a point. I don't think she would have ever left him. I think even if she was in this horrible domestic violence situation, she probably would have kept forgiving him. Like it was very, very toxic. Afro Man, I covered the Afro Man case, and I have a bunch of old colleagues who live in that county that are telling me I said this in a another person's YouTube show, but I haven't said it on mine. The Adams County, you could not find lemon cake for like 3 days after that trial. All of the bakeries, which is like a handful, and the grocery stores in that county, like sold out. You could not find it anywhere. Thank you, Kristen, for reminding me that I don't put this on my screen enough. And that is another reminder. I have no shame in asking you guys to do this. So please do it. Please make sure to hit the thumbs up button. If you are watching on YouTube, double check that you are subscribed. I greatly appreciate if you want to become a member. Any donations or memberships that you guys pay for are going towards the expenses related to heart operation that I'm having in May. So there's that. And then if you are watching on X, please make sure to press the heart and share. Why not? Yes, Karen Reed was Norfolk County. Okay, so the bullet hit him in his side, and I believe that's the only place. let me see if there's anything else worth showing you guys from this specific case, because I had planned on us talking about a new case today, but you guys are asking good questions. Do you want to hear? Yeah, I made up my mind. We're gonna do the closing arguments. Oh no, not the dictionary. Okay. I was just trying to find like the clip. Share this tab instead.
That's
Oh, I forgot. They started like right there that day. Okay.
Good morning. Thank you. Welcome back.
I never have finished doing this. Yeah. October 2nd. I agree. She was acting out of
Be
rage.
seated. Good morning, everyone. Appreciate your attention and timeliness. We'll start with the state. State, when ready.
Thank you, Your Honor. And Judge, may I have the, oh, sorry, I need to put my laptop in, and then may I have the monitor?
And I will switch over once the verdict does come in, if it comes in today. That'll have to do it.
Judge, I have it up on mine. I'm not sure why it's not coming up on.
This woman, sorry,
there you go.
just hitting
There we go.
everything.
Sorry
And
about that.
technology do not flow together.
March 7th, 2025 was the last day that Evan Barron talked to his dad. March 7th, 2025 was the last day that James David Barron spent on this earth. March 7th, 2025, after months and months of spiraling, after months and months of unhinged behavior, and after months and months of getting more and more obsessive and out of control, on March 7th of 2025, this defendant snapped for the last time. It started off fine, like any other day, but just like the
I hear you,
many, many,
Mama.
many, many times in the last months and months and months, this defendant started another argument with David. And it was the same argument that she had been starting since December. Lilia. Since the day that the defendant found out about Lilia back in December, her relationship with David Barron didn't stand a chance. And I want you ladies and gentlemen to understand reasonably so. I don't think anybody faults the defendant for feeling upset and angry when she found out that her boyfriend was sending money to a woman in a different country and paying for her daughter's rent. That's not what we're here to talk about. I don't want there to be any confusion about the fact that nobody liked David sending money to Lilia. His family didn't like it. His kids didn't like it. His ex-wife didn't like it. That's not the issue that we're here to talk about, is whether or not she had a right to be angry at David for sending money to Lilia. The question is how she handled the news of Lilia. That's why we're here. Because she didn't leave him. She didn't break up with him. She wanted to stay with him. She wanted to try and fix things. Great. That's her decision. She wants to stay with Mr. Barron. She loves Mr. Barron.
Barron.
She's so desperate and needy for love, and she feels like Mr. Barron is the love of her life, and so she wants to try and fix things with David. And so she finds out about Lilia, and she decides that she wants to stick it out, but at what cost? At what cost does this defendant go through to stick it out with David Barron? Constant questions, constant insecurities, constant arguments, constant fights, constant anger, constant aggression, reaching out to everybody about Lilia. Lilia was a secret to nobody in the defendant's world. She reached out to David's son.
JB too.
She reached out to David's ex-wife. She reached out to her sister Dana. She reached out to her sister Leslie. She reached out to Jen, to Jessica, to McLean, to Judy, to Mike. Anybody that would listen to her complain about Lilia heard about it. The obsession ran deeper than just the complaints to her friends and family because she took to Facebook. She found Lilia on Facebook. She found Lilia's daughter on Facebook.
This was crazy.
She's messaging them. She's somehow getting their phone numbers. She's calling them. She's getting her sister to try and call them. She's looking at who Lilia's following on Facebook to see how many men are following her.
I don't like
She's
this
getting her
lady's
sister
voice
to use
either.
Her real estate business to try and look things up about Lilia, to try and
That
look
was
things up
wrong.
about her daughter, to try and look things up about David. This obsession was so under her skin that it was literally all she thought about. It was all she talked about. It was all she argued with David about. It was all she ever wanted to talk about with anyone who was willing to listen.
True.
And she became unhinged. And that unhinged jealousy was not new to David, and it was not new to the defendant. Because before Lilia, there was Laura,
I like your
and
dog,
after Laura, there
Mama.
was Meg. And then came Lilia, and she just had a new reason to start fights with David Barron. She had a new reason to yell at David Barron. She had a new reason to focus her anger and her aggression and her obsession on Lilia. And so that brings us to the night of March 7th. And David did what he always did when this defendant would start a fight about Lilia: remove himself. Over and over and over again.
It wasn't
December
even her
28th.
husband yet.
Went to a hotel. January 4th, went to a hotel. February 1st, tried to go to a hotel, wasn't allowed to get in and get his stuff. He was trying to leave. She wouldn't let him. February 16th, locks himself upstairs in the guest bedroom. March 7th, locks himself upstairs in the guest bedroom. And this defendant did what she always did. She got angry, she got obsessive,
Yeah.
she got unhinged, and she spiraled for the last time on March 7th. So David goes upstairs, he's in the bedroom, and she goes and gets her Glock. She goes and gets her Glock, she walks up the stairs, she gets the gun,
My chat covers what?
6 inches
Oh, my
away from the
face.
door. She points, she listens, she aims, and she fires, and Mr. Barron's dead. And not only that, ladies and gentlemen, but we know that she was yelling threats to David before she fired that gun. Why do we know that? Because Mr. Barron is cowering behind a wall just on the other side of that locked door
I think
He's
they want to go
hiding.
home for the night.
from this defendant. What is she screaming? I'm going to shoot you. I'm going to kill you. There's no telling what she's screaming. She's screaming something that's scary enough for Mr. Barron to feel the need to be literally hiding behind the wall, behind the locked door of the guest bedroom. So she gets in. She sees Mr. Barron face down in a pool of his own blood. And now she knows she's in trouble. That's where the cover-up begins. And now the defendant is in self-preservation mode.
Give me a second,
She
guys.
sees Mr. Barron. She reaches down, checks his pulse. Blood all over her hands. She doesn't feel a pulse. She knows she needs a defense now. She knows she's in trouble. So what does she do? She goes and gets Mr. Barron's gun. And we're going to talk about why the evidence proves that that gun was never in the possession of David Barron that night. Why that gun was never in that bedroom until the defendant went and got it with her bloody hands and put it in there. And how do we know that? She goes and gets the gun. She walks. And keep in
Disputable.
mind, Mr. Barron's body is not here anymore because the paramedics have already taken him away. He's lying right there. She has to step over his dead body, through his blood, with her bloody footprints, to the bed. She gets the holster, unsnaps the holster, takes the gun out of the holster, walks back over to Mr. Barron's body, She knows she needs a defense. What's the most easy defense for her to think of? I'm going to make it look like he was firing this gun back at me. So she gets his Beretta. She bends down
Okay.
at a low angle, no more than 12 to 16 inches off of the ground, gets Mr. Barron's hand, puts it either on the gun, near the gun, and she tries to fire, but it jams. So she pulls the slide back, a bullet comes out. She leans back down, she tries again, jams again. Pulls the slide, bullet falls out. Let's try for a third time. Bends back down, fires the first shot, fires the second shot. Third shot goes off. Her hand, we know, got caught in the slide because she was holding it at an awkward angle.
Slide bite.
All the way down by Mr. Barron's body. So she gets slide bite there and there. From the slide, her hand is obstructing the slide. And we also know that because the casing never came out because she didn't have a good grip on the gun. She's holding it awkwardly and she shoots it that high off of the ground. That is how high off the ground those shots were fired. Look where the trajectory is headed. That high off of the ground, right to Mr. Barron's dead body. And we know he didn't fire those because he's face down on the ground dead. She did. There's the slide bite she got from when she bent down on the ground and her hand got caught in the slide. Then
I
what
was
did she do with
on
the gun? Well,
Mercator's show
to continue
2
on with
weeks
her
ago.
cover-up, she places the gun right next to Mr. Barron's left hand. It's no coincidence that that gun is laying on top of the pool of blood placed there right next to his left hand.
Maybe.
Then what does she do? Still in cover-up mode, so she goes and finds all the bullets she can find, all the casings that she can find, continuing to step over Mr. Barron's dead body, walking all through his blood, into the bathroom with her bloody footprints and flushes those casings. And we know that those casings were flushed from that upstairs bathroom because they were found in the septic tank line. Then what does she do? Keep in mind, what she does isn't render aid to Mr. Barron. What she does isn't try and perform CPR, something that she is, as a doctor, certified in doing. She leans down next to Mr. Barron's dead body and starts wiping out the blood because she's more worried about the blood on her feet and the blood on her floor than she is about her boyfriend's dead body laying face down right in front of her. She walks all over the room. She's carrying that towel. You heard Sergeant Durham talk about these blood drops. Those are blood drops from a 90-degree angle dripping off an object. Right mixed in with all those bloody footprints. She's walking around, wiping blood.
I think
carrying the
she
blood
was
towels,
crazy.
dripping everywhere. It's getting on the bed. That, ladies and gentlemen, is why this defendant has been charged with murder. Because unfortunately for the defendant, while she might lie, the evidence sure doesn't. So let's look at malice murder, count 1. These are the elements that you have to find beyond a reasonable doubt to find the defendant guilty of malice murder. That she, with malice, caused the death of James Barron by shooting him. That's count 1. Counts 2 and 3 are both felony murder. Count 2 is that in the commission of an aggravated assault, she caused the death of James Barron, and then count 3 is in the commission of criminal damage to property in the first degree. She caused the death of James Barron. And I see all of you guys writing. I just want you to know that you will have the indictment with all these elements. You'll have the charges. So this won't be the last time you get to see all these elements, just in case. If you want to take notes, absolutely do it. I just want to make sure y'all know this won't be the last time you see these elements. Count 4, aggravated assault. So like I said, count 2, felony murder, is based off of this aggravated assault, right? So she committed an aggravated assault, and in doing so, killed James David Barron. So what is aggravated assault? That she assaulted James Barron with a deadly weapon, in this case a firearm,
Hi, Myrtle.
an object which, when used offensively, is likely to and does result in bodily injury by firing said weapon through a door in the direction of James Barron. That's what aggravated assault is, essentially using a deadly weapon. A firearm is a deadly weapon. When used offensively, shooting it is likely to, or did in this case, result in serious bodily injury by firing the weapon through a door in the direction of James Barron. Doing that, firing a door, or firing a firearm through the door in the direction of James Barron, is what caused his death. That is both aggravated assault, count 4, as well as the felony murder, count 2. What is criminal damage to property in the first degree? This is the basis of the other felony murder. That she knowingly and without authority interfered with a door in a manner so as to endanger human life by shooting the door of a room that was occupied by James Barron. So what does that mean? Essentially what criminal damage in the first degree is that she knowingly interfered with a door, so that means damaging a door. That she, without authority, damaged the door. What that means is essentially When you have shared property, for example, they both share this house together. Both of their names are on the deed. This is a shared house. When you have shared property, she has to have the authority to damage the property. In this case, I don't believe that there's going to be any evidence that Mr. Barron gave her the authority to shoot the door and kill him. And she shot that door. She damaged that door in a manner that endangered Mr. Barron's life. That's essentially criminal damage to property in the first degree. Count 6, possession of a firearm during the commission of a felony.
I agree.
Very straightforward that she had a firearm while she committed the aggravated assault.
Hello.
And lastly, count 7, tampering with evidence, essentially that she knowingly concealed physical evidence. In this case, it's the shell casings and bullets with the intent to obstruct her own prosecution. So like I said, ladies and gentlemen, those are the elements that you have to find each one of those beyond a reasonable doubt in order to find the defendant guilty of each one of those counts. So the evidence doesn't lie. What evidence do we have that we definitively know does not lie in this case? We know that the gunshot was 8.5 inches above the lock. Not only that, but we know that this gunshot was fired at an upward angle, not at a downward angle in the direction of the lock, but at an upward angle in the direction of Mr. Barron. And I know that there was discussion, Mr. Willis had his arms and, said she was nervous, so she must have been going like this. Ladies and gentlemen, I don't know that she would be that far off shooting the lock off of the door if she closed her eyes. I think even if she had walked up to the door from right here and closed her eyes, she would have been closer to the lock on that door. At most, she would have been shooting at a downward angle towards the lock. But instead, she's quite literally shooting in the opposite direction of the door. That is the evidence in this case. That the shot was fired at an angle. What that means is that she didn't walk straight up on it and try to shoot the lock off like she said she did. She came at an angle.
Justice will be served
to better be able to aim
through the
at
system
Mr.
or
Barron.
karma.
Not straight on, while Mr. Barron's voice is coming from the right, but at an angle, so that she can have better aim to hit her bullseye. But it was 6 inches away from the tip of the door, the tip of her gun. 6 inches at most from that door is the evidence that we know in this case that does not lie. No one's disputing that David is behind that locked door, and the evidence is very clear that he is taking a defensive stance behind the wall, behind the locked door. Because he's, again, shot through the wall, through his left arm, through the side of his body, and then the bullet landed in the right side of his chest cavity. We know that the shell casings were flushed. She finally admitted it after she got caught with the shell casings having been flushed. And I want to talk to you about the holster. Why is the holster so important in this case? Because the defendant told Investigator Meffert over and over and over again that when I walked in that room, what was on the ground was the victim. My phone is what she said, so her phone, his gun, and his holster was laying next to his body on the floor. That's what she told Investigator Meffert over and over again.
There we go.
So let's look at the holster. First of all, we know the holster wasn't on the floor when law enforcement got there. Because
Okay, hold on.
So what?
I gotta turn this off in my ear. Okay.
All right, some administrative things. I believe we're on court 8, 9.
What?
Sorry about that. Court 9 is the note I gave to our alternate excusing her. Y'all were copied by email. Get that down in court order. C9. C10 is the 2-page question. C11, well, I won't number that yet. Well, yeah, I will. C11 is the question number 2. Y'all have been provided a copy by my staff attorney. Hear from the state first and then the defense.
Judge, as to question number 1, I believe that the correct response to this would basically just be yes.
Wait.
Isn't it true we should consider Mr. Barron's likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context? It's a reasonable person standard, so I think the answer to that would just be yes. And as to the second question, I think the obvious answer is yes.
Are you kidding me?
All right, so question 1, is there any additional information you can provide beyond what is already in the jury instructions related to aggravated assault, specifically regarding ... or committed an act that placed the person in reasonable apprehension, it says, or fear, apprehension or fear immediately receiving a violent injury, close quote, question mark. Page 2 of question 1, isn't it true we should consider James Barron's likelihood of reasonable apprehension, quote, of reasonable apprehension or fear of immediately receiving a violent injury, quote, from the perspective of a reasonable person in the known context? So that's Court 10, page 1 and
Argumentative.
page 2. We'll go to C11 in a moment. Defense.
You're talking about C10?
I'm talking about C10, which on your copy, it says question 1, and then there's a smaller to the top right that says 1 circled, which it leads me to believe that is page 1, and then 2 circled, which leads me to believe that's page 2. And so then there's a question 2. So on page 1 and 2, which is question 1, what say the defense?
The answer to the first question is the state must prove beyond a reasonable doubt the defendant's act of, quote, firing a weapon through a door, which is the allegata in count 4, placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the correct answer. The state must prove beyond a reasonable doubt the defendant's act of firing a weapon through a door placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the answer to 1. The answer to 2 is, on page 2, is no. Their question, whether or not they should consider James Barron's likelihood of reasonable apprehension or fear of immediately receiving a violent injury from the perspective of a reasonable person in the known context, that answer is no. The question is, you should consider whether the state has proven beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That's the correct answer to 2. They're confused, Judge, respectfully, and I suspected that they would be. They're confused about whether or not they can just say, was he in reasonable apprehension, and not connect it to the charged allegata, which is by firing the weapon through the door. And so the response should be, state has to prove beyond a reasonable doubt that the act of firing through a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That connects it up. And then the answer to 2 is no, it's not they don't just assume. They're asking, do we just assume whether a normal person would? That's not correct. The question is whether it's been proven to them beyond a reasonable doubt that he did. So the answer is no. They should consider whether it's been proven beyond a reasonable doubt that the act of firing a weapon through a door placed him in reasonable apprehension.
Response. State. You can take a moment.
Well, I was just trying to find I just couldn't figure out what page it was on.
Did someone
Charge
get
on
those 2
aggravated
questions?
assault.
I believe it's page 11.
Oh, thank you, Judge.
Because I don't have the pages in front of me. What were the questions?
240, 30.
I love the defense attorney
So
trying to dumb it down though.
Mr. Willis's first statement as to the first page about the state has to prove, and then basically just implanting the language from the indictment in the statute is a correct statement of the law. I don't see any problem with doing that. I think the only thing that Mr. Willis and I differ on is the response to page 2, because I just think we differ on the answer to the page 2.
What's your proposal?
My proposal was to just answer yes. I don't think there's any problem with restating the statute, including the language from the indictment, because again, that's a correct statement of the law. But as far as, isn't it true, we should consider the likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context. I think that's where we differ. I'm reading the way that we charged them.
Judges had it.
I think I would prefer, if we're not going to respond yes or no, I think that I would prefer, as to page 2 of question 1, that we reply with, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving violent injury, and leave it at that. Because that's a correct statement of the law. The state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. That's directly from the charge of aggravated assault, the pattern. And so I think the state would just request that we put just that one sentence from the charge in the response. I think that directly answers their question. It's a correct statement of the law, and so that would be the state's request.
I think you should say no as a response to 2, and then I don't have an objection to reading that part.
All right, so let's, if you would, and I'm not saying I'm necessarily going to give these, your response to the second part, page 2, if you would type that out and send Mr. Preston, we'll print it out. Defense, your response on page 1, same, and then we'll compare notes, please. And then we'll focus on that before we move to question 2, please.
I want to hit my head against the wall or a door. I really don't think she went up there with the intention to kill that man. I think she's just crazy and full of rage. The hormones had gotten to her. Do we have anyone watching on X? I'm looking to see. It says only 202 views, but I have 241 people watching right now. Like, I don't understand. Just from X alone. What? Anyone would be in fear of dying after getting critically injured. Yeah. I mean, I don't understand why the jury thinks it's their job to change criminal law statute in the state of Georgia. Like,
Defense need a printed out copy, or you find on digital
Of the,
what the state just emailed.
I emailed it to you.
I have it,
Okay.
Are you okay with a digital copy?
with what they just sent.
Would you like a printed out copy?
No, sir.
Okay.
But we're not consenting to that. We want the word no in front of it. Okay.
hi, Jim.
I understand that.
You can either rewind like 60 minutes ago.
State, are you okay with the digital copy, or you want to print?
I'm good.
I don't
I'm
want
good with that,
to.
Judge.
I don't want to
appreciate it. Thank
talk
you.
over the judge. I'm afraid he'll get mad at me. She is a liar. Going to get her phone red herring. She went up to lure him to the door, then firing. Oh man, I think you're giving her way too much credit.
All right, focusing our attention on Mr. Willis's
I can answer in 1 second, Jim. Just
proposed answer.
hang in there.
State must prove beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving a violent injury.
No, I have no objection with that, Judge.
Okay.
That will be the answer to
So him being in front of the door,
the first page, question 1.
reasonable injury. In the future, when
The defense
we have notes, I'm just
is
gonna write them
okay with this, but wants the qualifier of no in the beginning, if I
Right.
understand. State's proposal, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury.
so was he afraid he was about to be injured? No, I don't know, but I think I don't think the majority of people necessarily agree with me. I don't know. I love
The
that you
reason we want
guys.
the no, Judge, is because it's a specific
Challenge.
question. Isn't it true? First question doesn't have that, just they want more information. So isn't it true? The answer is no.
They're really.
State, I think the defense makes a fair point.
I think they
I'll
do
hear it
too.
From you.
The reason why I'm hesitant to put no is because I'm doing some research on the validity of the no, and I think sticking with the pattern charge is a correct statement of the law, and
I'll give you a few moments to continue
Judge.
research.
So are they just looking up case law? And how do you even look that case law up? I don't even think ChatGPT would get that correct. Yes, she did, Jim. Okay, so she got mad, took her personal weapon upstairs, said, "You better open this door and give me my phone and car keys right now, or I'm gonna shoot this lock off this door." And she did just that, standing 6 inches away from it with a Beretta. Succession of 2 quick shots, one of which went into his side, into his lungs, and he passed away. It's not dumb. Like You're welcome, Jim Cole. Please make sure to give this stream a thumbs up and the channel a follow. I want to hear what the state's going to say. Carl, are you sure it didn't go into his side, penetrate the side first, and go into his lung? Oh, he went upstairs to lock the door because he didn't want to be bothered by her because she was bringing up the Lilia stuff, the Romanian girl stuff, and he he was mad at her because he had discovered sexting text messages on her phone with another man. And she had said, well, as long as you're going to be supporting 2 women in Romania and giving them a green card, sorry guys, then I'm going to continue talking to this guy. Just 1 second for the dogs to calm down. Whoops. Time's up, state.
I'll hear from the state. The jury asks a specific question and the answer is no. I'm inclined to put no period and then put in the response that the state proposes, essentially no period return, and then what you've provided by email.
I'm sorry, so putting no and then what I typed out essentially?
Whoever did it, Ms. Ali's email.
Yeah, I'm using her computer, sorry.
Yeah, that's fine.
Okay.
That's not a final ruling, but that's where I'm going.
Ladybug, if you are being absolutely truthful with me, I believe that, and I've come to that assumption on my own. Like, she does not strike me
Judge, I'll
as
just
someone
note, my
that would be
counsel has reminded
unpleasant.
me, we had asked the court
To know.
not to charge
Yeah,
on
they are.
both species of assault, and we're not waiving that previous objection to the charge. This is a previous objection we had, so we just want to note that we're not waiving that. We still don't think that we should have charged on both species of assault, the intent to injure and the reasonable apprehension. And after the court sends it back,
Noted.
yeah.
Riley.
I think, so they're asking from his perspective. They're saying, so essentially, obviously, the right answer is, from his perspective, was he placed in reasonable apprehension of receiving immediate violent injury?
The person.
Correct, which would, in this case, would be Mr. Barron. So maybe just to make it, instead of putting a yes or no, instead of putting the person, we put in James Barron. So it reads, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed James Barron in reasonable apprehension of or fear of immediately receiving a violent injury. That way it's clear it's from his perspective. So it's beyond a reasonable doubt. So it's reading that committed an act that placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Which is what I proposed initially.
Well, if you proposed initially, then assume you're good with it now.
I'm good with it now. As long as I have a no at the beginning.
Well, that's what they don't want, so
What? I'm sorry.
What?
he wants the no at the beginning.
Yeah, I would just rather not say yes or no and just restate the law, but including his name so that it's clear that it's not just any person, it's James Barron in reasonable apprehension or fear of receiving injury. Just because their question is kind of confusing, so answering with a yes or no is what concerns me, which is why I believe restating the law, but including his name to make it clear that it's not just placing any person in reasonable apprehension, but it's that the act placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Defense can take a moment.
I see what you did there, love.
I'm sending the court my proposed response. It still has a no at the beginning.
Am I copied in it? Or
Yep,
Can
you are.
can you copy now?
I just sent it.
That's
Sorry.
okay. I have my phone.
Let me forward it to her. Previously, they asked a specific question and we gave them a yes or no. So I think we should tell them no.
I think he was just
If it
tired
doesn't
of
tell
her
them no, then they think
yapping.
they're on the right track and they're not. So
I have no problem with what Mr. Willis has just sent. The state must
Hi,
prove
Washington.
beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving. In reasonable apprehension, he did leave out the or fear, reasonable apprehension or fear of immediately receiving a violent injury. I have no problem with that. Except for adding the or fear.
Oh my
but it's
God.
not from the perspective of a reasonable person.
I know.
That's what
I'm saying-
hasn't been corrected is what I'm saying. If we don't tell them no, then they can think, well, yeah, but did he do it? But now I'm just going to guess and see whether a reasonable person would. The answer is no, so we should tell them no respectfully.
Right.
Why do some people call him David Barron and the other people call him James Barron? And Josh has said this to me. I think it's depending on her family versus his family. One side called him David and one side called him James. But what did the Romanian girl call him? She called him Daddy. My Eastern European accents are always waiting to come out. I'm reading what some other law tubers are thinking in terms of the jury. Give me 1 second. Yes, I love them. My name is Natasha and I live in the Soviet Union. I like to drink vodka cocktails and eat sardines. Do you want to be my daddy? It only costs $3,500 a month. Carl, you're so funny. Man, you know
What's the
who?
state's concern about telling them no, it's not a reasonable person?
Because I find the question to be confusing based off of how they're viewing it. And I don't think that there's any error in simply restating the law to them, but including the facts of this case to make it clear. Like Mr. Willis's proposal of you should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension, and then adding or fear of immediately receiving a violent injury is an absolute correct statement of the law. It instead of just rereading the charge to them, it includes both the indictment language as well as the victim's name. And so I think that that helps answer the question without potentially incorrectly answering what they might be trying to figure out, because I find their question to be confusing. And so I would prefer to just insert the facts of this case to the law and read that to them.
Such a heavy sound.
It answers the question without a yes or no. It gives them the correct law without giving a yes or a no.
Last word, defense.
They've asked, isn't it true? The answer is no. We should tell them no and then tell them what the correct answer is.
Guys, I've lost what the question
Because I mean, the
is.
reason why I think it's confusing, Judge, is because it's not like
We'll go another round.
it's not like anybody could ask Mr. Barron, were you in fear? Because he's dead.
Sure
And
can't,
so
Murphy.
Even though it is obviously that the state has to prove whether or not he was in reasonable apprehension or fear of receiving injury because he's dead and nobody can ask him, it's really up to how they're viewing the evidence in this case as far as whether or not he was placed in reasonable apprehension or fear. And so that's why I think that that's why I think this question is confusing based off of what we know about the law. And so I would prefer to just give them the correct law. There's nothing improper about giving them correct law and then including the facts of this case. It's answering the question without improperly assuming what they're asking is, I guess, the reason why I'm hesitant about giving a no.
All right, so not to quibble, but it says, isn't it true we should consider James Barron's likelihood of, quote, and they're tracking, reasonable apprehension or fear of immediately receiving a violent injury, close quote. That's the setup. And the question is, from the perspective of a reasonable person in the known context.
And that's why I don't think it's necessarily no, because again, nobody can ask Mr. Barron in that context if he was scared because he's dead. And so I don't know exactly what they mean by that, because typically if you have a live victim in an aggravated assault, you would elicit testimony about how did that make you feel? Were you scared? That's how you're able to prove this element. When you have a dead victim, you can't do that. And so you really are kind of judging the evidence based off of, you know, if a person like Mr. Barron were in his shoes based off the evidence, was he in fear? That's why I think this question is confusing, because I don't know how they're thinking about it. And so to answer no, I think would be improper, because that implies that basically the state had to, we can't ask him if he was in fear. So they're going to have to kind of put their own imagination in the head of Mr. Barron in that context to say, was he in fear in that moment, which might be to them a reasonable person in that context.
We're talking about imagination with a woman's life to a jury.
All right, last word,
Are we sure she wasn't done
defense.
Yeah, the answer is to their question is no,
yet?
because
For
it
the
is
seventh
no.
time.
It's not from the perspective of a reasonable person in the known context. That's just false. And to not answer that is a mistake. So I think the answer is no.
That's where we're at right now.
And one last thing, Judge. Ms. Bennett had said I didn't put the word or fear in my charge.
You were right.
And I just noted this error. In the statute, it actually doesn't say the word fear. It just says reasonable apprehension of receiving a violent injury. So the word or fear doesn't belong in the charge. I don't think we need to do anything about it now, but we don't want to remake that error by putting the word or fear, because it's not in the code.
I think that's pattern. This is straight from the pattern,
It is not in the code for assault.
straight from the pattern jury charge.
Assault says.
So since she talked, do we have to do this again?
In reasonable apprehension of immediately receiving a violent injury, it's in 16.520A2. So or fear is not part of the code.
I
So it
bet
shouldn't be in the
her
recharge.
professors in law school like dreaded her. I don't know why. I just get the inkling. I told you guys, those of you who've been watching since we started this trial like 5 days ago, I don't know. I said all along that I thought they overcharged her. And now we're seeing it in real life, the consequences of what happens when you overcharge someone. I don't know if she's crooked. Part of it, I explained this yesterday. I found out that it was the lead investigator's very first homicide, which I had said, I bet this is this guy's first homicide because this is such a laid back area. It's locals, not, it is touristy, but it's like older tourists, to put it mildly, and it's no Panama City. And I think that he and the ADA just got a little too excited to do something other than a DUI and went a little overboard. That's what I am concluding in my rational brain.
That's the most recent.
Yeah, so am I. You're talking about the state. I'm referring to the assistant district attorney, the lady with the very nasally voice.
This is that's my. Is this good?
She was vicious yesterday in her closing argument rebuttal. I mean, I feel like Attorney Morris
Anything else in the state?
probably went home and cried.
No, Your Honor. I just double checked that fear is in the pattern charge, so it wasn't an error.
This is why people don't want to go on dates with you.
All right, the final answer is on this is that I am going to put the no because it is responsive to their question. I hate to get into minor semantics, potentially no comma and then lead into, which is, I think maybe the better way to do it.
That's fine.
Okay. And then I'm going to go with Mr. Willis's 531 email language, but adding the two words "or fear" after the word apprehension.
Yes, Your Honor. Thank you.
So no comma, you should consider whether this, I apologize. You should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury, period.
Yes, Your Honor.
Okay, so
Let's see.
am I
hold on. Let's
correct that
C10,
the judge said they were
page
only going to go
1 and
till
2,
6?
Over defendant's over state's objection of the no. Sorry. Are you ready for question 2?
I think we are both in
Yes.
agreement, Judge, that the answer is yes.
Answer is yes. And will the court be sending, when you send back the answers, do you send back their sheet so that they can refer back to know what, you know what I'm saying? Because if they don't have their note because they've handed it to you,
Yeah,
and they don't.
Yeah, so to answer your question, the packet you have is stapled with 3 pages.
Yes, sir.
I returned that back.
Got it.
The original is with the court reporter, so you're correct. They,
Okay.
just in case they've forgotten the question, they're provided with what their question was. And then collectively, I'm going to finalize the paper that will go back as C12.
Got it. Thank you.
Thank you.
Okay. Okay.
Giving the court reporter C11, which is question 2. Hanging the court reporter, what I believe is C12 is what we agreed, or what I stated, which is a copy of the response. Thank you. Handing the chief bailiff a signed copy of the response.
That's what I thought.
As well as photocopies of the 3 pages that they presented to the court. Defense, have you had a chance to review C12?
Yes, sir. And we have no objection to this proposed response. We will just restate our previous objection that ties back to the demurrer with respect to charging both species of assault for the record, and ask the court to rule again on that, just so we don't wait.
Noted and denied.
Thank you.
And then you object to the no comma, but other than that, we're moving on.
Yes, Your Honor.
Thank you.
She was objecting to a comma.
Anything else from the state?
No, Your Honor.
Anything from the defense?
No, sir. Well, let me ask this, as far as timing for us.
I'm just as anyone else who's in the courtroom, I can guess. I mean, I would guess that they're going to review that and either keep working for longer or potentially reach a verdict or potentially say, can we come back another day? So they're either going to let us know, I would think, within about 15 minutes or so, or they're going to do a deep dive. Yes.
Why are you guys going up there? We want to hear. Oh my God, I heard him say something about his son. Are you for real?
That will be in recess. Thank you.
And here comes the jail person, sheriff, to put her back in the cell. Good evening. Okay. All right. So, can I recap? I would like to show the video, the closing arguments. But I can very briefly say, I don't feel comfortable saying what we just watched because I thought, I'm going to be real with you guys. I literally thought of like 30 things while we were watching that. I think the majority of it was fighting over I know it was fighting over the wording, which had to do with the jurors' belief of intent and whether or not the decedent was scared for his life because of an injury. It was what we have concluded in this chat is that the assistant district attorney has just gone rogue and she is up to fighting anything and everything that comes her way. So the judge is still on the stand. Okay, now he's leaving. All right. Thank God I have that next to me. All right. So here's the, we're going to switch back to this.
And there's blue fluorescent on the snap of the holster. But notice where there's no blood, the strap.
Here, I'm going to
There's
make
not a
myself
single drop of blood on the snap of that holster. What is that consistent with? Someone with a bloody hand picking up the holster with their other bloody hand, unsnapping the holster, taking the gun out and putting it on the bed. That's what that evidence shows. If that holster was laying next to Mr. Berenstain body, there would be at least one singular drop of blood on the snap of that holster.
They were fighting over
And we know that she didn't put the holster on the bed because her footprints are leading right up to the bed. Her bloody footprints lead right up to the bed where the holster is sitting. And not only that, but she places the gun next to his left hand after he's been killed. And I know we heard lots of different testimony. First, with investigator Mefford, she said, oh, the gun was laying right there and I just like pushed it out of the way. And then she testified that she tried to kill herself, but the gun was in the holster on the bed. And that's when she took the gun out of the holster. And then she said, actually, I don't remember where the gun was. And I don't remember if the gun was in the holster. And then it just turned into a bunch of I don't remembers. She didn't push the gun out of the way. She didn't go pick up the gun to shoot herself. She got the gun, staged the crime scene, and then planted the gun next to his left hand. We know that she tried to wipe up the scene. She has the bloody towel with all the droplets all over the bedroom. And we know that David had absolutely no alcohol in his system at the time of death, regardless of the continuous times that she tried to tell people that he'd been drinking too much that night. Jack Daniels and beer, Jack Daniels and beer. I told him he was drinking too much. And he got mad. He was drinking Jack Daniels and beer.
Well,
no, he wasn't.
Hold on, Mitchell.
Then she tried to cover that up by saying, oh, well, what I meant was earlier in the day, he was drinking too much. That's what I meant earlier in the day. There wasn't even a Jack Daniels bottle in the house. There wasn't an empty beer can in the house. He has my journal. He has my phone. He kept yelling, he has my journal. He has my phone. I wanted my journal. I wanted my phone.
Floor.
No, he didn't. The journal was downstairs in the living room. The gunshots fired outside the bedroom, no more than 16 inches off the ground. And we're going to talk about that again later, but that evidence does not lie.
Do you guys hear them
What is
whispering?
malice? Malice is not ill will or hatred. The unlawful intent to kill without justification. Essentially, what malice is for the malice murder is the intent to kill. No premeditation is required. I know that TV sometimes likes to make everybody think that you have to have premeditated murder. You have to have this plan, this thought out premeditated plan. That's not the case. Malice can be formed in an instant. The second this defendant got her block,
Okay, good.
walked up to this door and held it 6 inches away from the door, that is malice. The intent to kill has been formed from the second she decided to raise the gun, point it at the door, and fire. No motive is required to be proven, although in this case there's plenty of motive, but I did want to put that in there because that is the law, but technically no motive is required, and that's because sometimes people kill people for no reason at all. In this case, we know that's not the case, but that's the law.
She
So how do we
shot
know
it
that this
2
defendant
times.
intended to kill Mr. Barron? Well, like I said, going to get your gun while he's already locked himself in a bedroom door, walking up to the door 6 inches away at an angle and firing in the direction of his voice while threatening him is malice.
I
Mr.
think he
Barron,
was sick and tired of
hiding
hearing her voice
Behind this wall
and mad at her.
while she's shooting at him is malice. Going to get Mr. Barron's gun, planting it in the crime scene to make it look like he threatened her with it is malice. Getting that gun, placing it next to his dead body to make it look like he was shooting at her, and then telling the officers on scene that he shot at her is malice. Standing over his dead body, getting a towel and wiping up the blood is malice. Walking over his dead body, through his blood, collecting the shell casings and flushing them down the toilet to hide evidence is malice. Control follow through, hit the bullseye, malice. Looking at the Hall County Jail, and I know that there was discussion about whether or not she deleted that search. I don't know why that mattered. Whether or not she deleted the post wasn't the point. The point was 3 hours before she calls 911 for murdering her boyfriend, she's looking at a tab on her phone about the Hall County Jail. Days
I want
before
to
the
get to
murder,
him.
she's looking at the Hall County Jail. That's malice. We know that Mr. Barron is dead, and we know that she shot him. The question was why? Malice. Because she intended to kill him. Aggravated assault. I want to talk about the underlying felonies before we get to the felony murder. We know that she had a firearm, and we know that when you shoot a firearm at someone, it can result in bodily injury, and in this case did result in bodily injury. And we know that she fired that gun through a door in the direction of James Barron. That is aggravated assault. You should find the defendant guilty of count 4. And because he died, when she intentionally pointed that gun in the direction of Mr. Barron and fired, you should find him guilty
Oh, I'm going to do a poll.
of count 2 felony murder. No malice is required for the 2 counts of felony murder. Malice is not required. All that's required for you to find the defendant guilty of the 2 felony murder counts is if you find that the elements of each one of those underlying felonies has been met beyond a reasonable doubt, and you find that Mr. Barron is dead. So let's talk about criminal damage to property. Well, we know that she intentionally shot the door. She's told you that over and over and over again. Why she shot the door is what we're differing on with the defendant. But there's no debate about whether or not she knowingly interfered with the door, and there's no debate about the fact that her and Mr. Barron own that property together, so she's without authority to do so. And she did it in a way that endangered human life because Mr. Barron's dead. Damaging a door by shooting it when someone is occupying a bedroom is endangering a human life. Even if Mr. Barron hadn't died, that is endangering a human life. Even if she completely missed Mr. Barron, getting a gun, shooting it at a door endangers human life when there's somebody on the other side of that door. That's why you should find the defendant guilty of criminal damage to property in the first degree, and that's also why you should find the defendant guilty of count 3 felony murder because he did die. Because she fired a gun at a door in a way that endangered Mr. Barron's life because he died. This count 5 is very straightforward, this is count 6, I apologize. She had a firearm when she committed aggravated assault. That's it. We know she flushed shell casings and bullets. And what other reason does she have to flush that unless it's to obstruct with the prosecution of herself? We know that she was doing that to obstruct with the prosecution of herself because everything she did that night. she did to try and obstruct the prosecution of herself. Planting the gun, wiping up the blood, flushing the shell casings, lying, everything she was doing to protect herself. That's it, ladies and gentlemen. Those are all the elements for every count that this defendant is charged with. To find her guilty
Streamers.
of every
There
single
you
count
go.
indictment beyond a reasonable doubt. That's everything.
Oh, up to you. I
What about
hope
the
that
defendant?
you will
What did
come
she
back
say? Because, well,
on
this is what I'm gonna
Tuesday.
why we know she did over and over and over and over and over again. So first, let's talk about her behavior on the scene. Contrary to what their paid for opinion expert said on the stand about her opinion or about her behavior on the scene, we all saw the defendant's behavior on that body cam. We all saw 3 hours of it. The fake crying, the dry heaving, the fake
Is
throwing
anyone
up,
watching on
the
the
fake
other
passing out
phone?
with her eyes wide open. I don't know why the question was asked about, can you have a panic attack with your eyes open? That wasn't what I asked. I asked the officer if her eyes ever closed when she passed out. When she slowly and dramatically collapsed to the ground like 3 or 4 times with her eyes wide open. The 3 hours that she sat there and wailed without a single tear coming out of her eyes. And ladies and gentlemen, I'm a big crier, so I feel like I'm an expert in this subject.
I am a big crier
When you
as well.
cry, even at a slow, silent cry, you're going to have a snot. You're going to be wiping your nose with the back of your hand. You're going to be wiping your nose with the sleeve on your arm. You're going to need to blow your nose. Your nose is going to be all red. You're going to be wiping tears from your eyes. Not once. You watch that 3-hour body cam again if you want. You can ask the judge and look for it. And
At all
wait for
times.
one single time where she wipes a tear from her eye or snot from her nose. And you won't find one. She put on the world's biggest show in the history of shows. She really should be an award-winning actress, to be honest, because that was a show. And not only that,
If you hear my dog in the
but
background,
what
he's
did she say
fine.
on the body cam? Because she's lying through her body language, but she's also lying with her words. From the second deputies get on scene, she's lying to them. He made me go up
He
the
has a
stairs.
skin
I got
infection.
dragged down the stairs. He shot at me. She says that 5 times I counted. He shot at me. 5 times. She told responding officers while her boyfriend is laying dead upstairs, tells them that he shot at her and that is a complete bull-faced lie. He is literally lying face down and pulled his blood upstairs. She's pretending to be distraught about that while lying about him shooting at her. He grabbed me by the neck and dragged me upstairs. A lie. I said he'd been drinking too much. She says that twice on body cam. I said he'd been drinking too much and he got mad at me. She's lying about him shooting at her. She's lying about him dragging her up the stairs. She's lying about him being drunk. Lie, 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 lie from the second.
Okay, they're back. They're back.
Made me leave
They're
and I didn't see
back.
why. We know that story changes a whole bunch.
Hold
So
on.
let's talk about what she told investigator Mefford. How about the kitchen incident? The elaborate, long, detailed.
Man, I really wanted to have you guys listen to the defense closing because I thought it was great. Okay, so if you guys are just now joining us, for some reason you haven't been watching us for the last 3 hours or the last 5 days or since I started doing this like a year ago. My name is Lacey Jane. This is Criminally Confident, and we are covering the case of Georgia v. Suzanne Mericle, spelled Mericle. She was a prestigious dentist who practiced on St. Simon's Island, where she also grew up, and she is currently being held. If you're looking at the screen with the courtroom, she is all the way in the left-hand corner wearing the white sweater. I feel bad for this poor woman. She's had the same sweater on, I believe, for the last 3 days. She was 61 years old when she was arrested, and she is in jail because she is being accused and has just gone through a trial of allegedly, let me read the charges so I don't mess up. Malice murder, felony murder, aggravated assault, and possession of a firearm during the commission of a crime. The jury went out yesterday and they came back almost immediately. And one of the jurors had said he refuses to debate or deliberate. He's sticking to his opinion. That is that. And so the foreman of the jury sent out a note and was like, yo, Mr. Judge, we got a problem. And the judge brought them all back in. reread the jury instructions, sent them back to deliberate, and 30 minutes later they were like, man, we gotta go home. So they went home. They came back the next day at 9 a.m. and the jury has since come back twice with questions. And they are, in my honest opinion, far more legalese-esque questions. I recognize that's a whole bunch of words put together, but they're overthinking what the questions are, and that is indicative of that one rogue juror has apparently had a change of heart and is willing to consider opinions other than his own right now. So, more times than not, when a jury is deliberating and it's Friday, they will return a verdict just to get out of there and not have to come back on Monday. It's sad, but it's the honest to God truth. So, we have been listening for the last hour and a half, 3 hours. We have seen 2 questions come through, which I don't, Josh, the guy in the chat who was actually there in person last week and this week for a few days, he thinks that it was indicative of them coming closer to coming to a verdict. In my opinion, I don't think they're at a verdict, but I really don't see them going deadlocked. It looks like they want to, I don't know. This is the first time I've ever seen this many questions and this much anger with the jurors, the ADA, the defense attorney. This is wild. Thank you, JBS, so much. JB2, rather. Thank you. I greatly appreciate that. So does my heart. And they were told that they had they could go as late as 6 o'clock. I think that's what they said. But honestly, the 2 attorneys, the assistant district attorney and the defense attorney, went up and talked to the judge privately. And I think if I were a gambling woman, and I am, I think they both said if it's a matter of letting them continue and avoid coming back on Monday, we're all for it. But they have to make sure that the jail can, pick up and take back Suzanne Mericle, who's sitting there. There's a lot of things that go involved. Are they going to buy them dinner? There's just a lot that goes into that kind of consideration. They've already been told they cannot come back on Saturday. So we are waiting to hear if they came to a verdict. And if they did, it will have been a hastily thrown together verdict, in my opinion, after having just asked that question and not nearly enough time to talk about it with all of them. That is my honest opinion. I love to hear yours, so let me know if you would disagree or agree. Or if they are deadlocked, or if they have another question and they're just going to come back on Monday. And this is important, mods, if you could please write this out so that I can pin it to my screen. I will, if they come back on Monday, I will do a stream. But my normal schedule is Tuesdays through Fridays, and next week it is going to be I don't know. I think that 3:45 has kind of been killing it. So let's say 3:45. And yeah, hopefully one of the mods wrote that down so that we can pin that. So if we leave tonight with a verdict, then I'll see you guys on Tuesday at 3:45. If they are going to come back on Monday to continue deliberating, I will see you guys on Monday. And if you basically what I explained last night, I need to have you guys turn on your notifications on YouTube. So you go to my channel page and there's like a little bell and you click that and select all notifications. And that way you get alerted when I go live on Monday. Otherwise, if they don't come to a verdict Monday morning or early afternoon, I'll go live at 3:45. But I don't foresee that happening, to be entirely honest. I just pulled up a tab to do something. I'll write it in the chat. Give me 1 second. Okay. That's a really long thing to write. Oh, my Discord. If you guys want to join my Discord, because Scott, one of my mods, was so helpful and showed me how to create a channel where for like my live stream alerts, so I could so that you guys can join my Discord for stream alerts. There we go. And he showed me a bot that I can use that like pushes out notifications when it knows that I'm going live. I didn't even know these things existed. I didn't even know half the things that people have assumed I know. Okay, what is taking them so long? This is wow, man. Okay, so next week's schedule, Tuesday through Friday at 3:45 p.m. unless the jury returns on Monday. If the jury in that case, unless they come back on Monday, make sure to turn on notifications. And this is for X too. Make sure to turn on those notifications so that you get an alert when the stream pops up on X. Okay, turn on notifications so you don't miss the verdict. Okay. This is going to be a long one. So I'm going to have to talk like this for anyone that's watching horizontally because the words come up to like right here. Okay, I want to leave that up for a little bit. Yes, yes, yes. You're so welcome. I didn't want all of you guys to leave without knowing my tentative plans. Actually, I'm going to switch the camera for a moment so I can double check that I don't have anything on Monday. Any doctor's appointments mostly. That's what's been taking up all my time. Okay. No. And any also I have a notification set for Discord already that alerts you like when I do a live stream. So I guess I didn't need to do the other one. My mom left me a voicemail today. I'll let you guys listen to it.
Hello, Barrister Lacey. I'm calling to inform you you won your first case.
Why doesn't that go on speaker?
Barrister Lacey.
What?
Calling to inform you you won your first case. Call me back.
I helped her with her YouTube, not YouTube. Yeah. If you guys couldn't hear it, that sucks. She had a problem. Well, we both had a problem with the Airbnb we stayed at all month last month. We chose the Airbnb because it had a private pool, and the pool did not work the entire month. And so I requested a partial refund. Man, sorry you guys couldn't hear Dolores. I already did the Corey Richens case. That was the case I just did. So if you go on my channel, one of the tabs says live. It says like videos, posts, community, and there's one that says live because I only do live streams. I don't do videos. I will be for my surgery, but I'm vlogging that experience. But the if you go to live, you'll see every single live stream that I've ever done, and you can tell. Oh, my eyes deceived me. You can tell my older live streams from my newer ones for sure, because I look like a fish out of water. Okay, he's back. Why can't we hear him? It's not. Turn on the mic. Okay.
I understand it's deeply impactful. This is a relatively long verdict form, and I will have the clerk read it aloud.
Oh my God,
after
we have
showing it
one.
to the lawyers. Let's bring the jury back. welcome back. Thank you. Madam foreperson, members of the jury, everyone can be seated. Thank you so much. We appreciate your hard work on this matter. I'm not going to have you read the verdict. If you would you please hand the verdict to the chief bailiff? Representatives of the state and defense, please approach. Thank you.
Thank you, WB, for the jewels. And the super chat. Yeah. Okay, here we go. Okay, let's see if we can tell by. I feel like if the state loses, she would just like fall down on the ground and start crying. I honestly, yeah, so she's guilty. She has to be.
Madam Jury Clerk, please publish the verdict.
In the Superior Court of Hall County, State of Georgia versus Suzanne Mericle, case number 2025 CR 516. As to count 1, we, the members of the jury, find the defendant Suzanne Mericle not guilty. As to count 2, we, the members of the jury, find the defendant Suzanne Mericle not guilty. As to count 3, we, the members of the jury, find the defendant Suzanne Mericle guilty of felony murder during the commission of first-degree criminal damage to property. As to count 4, we, the juries of the members of the jury, find the defendant Suzanne Mericle guilty of the lesser included charge of reckless conduct. As to count 5, we, the members of the jury, find the defendant Suzanne Mericle guilty of first-degree criminal damage to property. As to count 6, we, the members of the jury, find the defendant Suzanne Mericle not guilty. As to count 7, we, the members of the jury, find the defendant Suzanne Mericle guilty of tampering with evidence. So decided this 27th day of March 2026. I'm the foreperson.
Madam foreperson, is that the jury's verdict?
Yes, Your Honor.
May this jury be excused.
No objection.
Judge, I'd like to poll the jury, please, court.
Members of the jury, in a moment, I'm going to ask you some questions, and I apologize, I don't have your numbers memorized, but we're going to pass you a wireless microphone, and if you would identify your juror number and answer questions, okay? Please hold.
Okay. What is the Georgia period of time period? Okay, so aggravated assault in Georgia can be 1 to 20 years. These are things that we should have probably done. They usually don't have, 7 counts in this sort of trial, though. Okay, possession of a firearm during a crime.
Defense, the 3 questions I'm going to ask each individual jurors. Is this your verdict? Was this your verdict in the deliberation room? Is this your verdict now? Any objection from the defense?
No, sir.
Any objection from the state?
No, Your Honor.
Madam foreperson, and y'all can remain seated if you choose, if you wish to stand that as well. Madam foreperson, what's your juror number?
25.
Question 1, is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
State your juror number.
2.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number, please.
18.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number,
81.
They already handcuffed her.
is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Thank you. Juror number
51.
51. Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror
Number 4.
Number 4. Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number,
89.
is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
65.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
94.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes. 10.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Yeah, so she got felony
Is
murder.
this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
What number was he? He seemed sad.
Do you have his number?
I apologize. Thank you. What's your number?
28.
Thank you.
I wonder
20.
if he was the iffy one.
Is this
No,
your
20.
verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Oh,
Thank you,
really,
members of the
Mitchell?
jury. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, sir.
I'm going to excuse this jury with gratitude for your service. If you would, you're excused the deliberation room. I will speak with you briefly, not discussing the case, and we will allow you to depart. Thank you.
I'm reading in the
Please
In
be
the
seated.
chat.
Thank you.
the way that
The jury's verdict speaks the truth. It is generally my custom to delay sentencing approximately 30 days. I plan to do so in this case. I propose the date of May 8th.
day after my birthday.
I am proposing the date of May 8th. If that is not appropriate, I will provide
That's Friday.
other dates that may be available. May 5th, April 30th, May 1.
May 8th might be okay. I have trial in a different courtroom May 4th, but May 8th is a Friday, so
You have what? I'm sorry?
I have trial in a different courtroom on May
Okay.
4th, but May 8th is a Friday. I don't anticipate that trial to take the whole week, so I should be freed up by May 8th. That would just be my only potential conflict.
It
So
works for us, Judge.
we can, is there an available date the week after May
I didn't look that
8th?
far.
Okay, I'm sorry.
May 11th is a Monday.
May 11th would be perfect, Judge.
Folks, the date for sentencing will be May 11th. Any preference on AM or PM? I might slightly prefer 1:30 PM.
I think that might be best, Judge.
That works for us, Judge.
She wasn't found guilty on count
Same courtroom you're in now,
1,
May 11th,
2,
2026,
and 7.
1:30 PM. Anything else from the state?
No, Your Honor.
Do you have the verdict form? Okay. Verdict form is with the clerk as of right now. Anything else from the defense?
No, sir. Thank you.
Remand, obviously bond was denied, remand to the sheriff's department until May 11th sentencing.
Thank you, Your Honor.
Thank you.
That helps because I'm reading the court TV chat, and that's perfect reason why to not believe the internet. Look at her. Aw.
Lawyers,
I
the clerk's going to make you a copy of the verdict.
I am an empathetic person, and so it's natural for me to like not want to see an old lady in handcuffs.
Adjourn for the day. Be back May 11th, 2026, 1:30 PM.
A week of my surgery. And that investigator, he's just happy. He just won a friggin' case. Wow. So I got a question. Which case is next? So on Tuesday at 3:45, let me get this out of the way. Tuesday at 3:45, I have a couple ideas. I listened to some of the testimony from the Hawaii case going on right now with the anesthesiologist who is being accused of trying to eliminate his wife at the time. I am having surgery on my aorta and my heart. And someone asked that. Sorry. So it was very interesting. I'm torn between doing that or revisiting an old trial. And by old trials, I was thinking of Kyle Rittenhouse because that is one that I have not covered and I did not watch. I had a really busy job at that time and wasn't able to have like any hobbies. So the Hawaii one is pretty wild. It's basically this couple who went hiking the day of the wife's birthday, and her birthday was March 24th, and on like Christmas Eve, the husband saw a bunch of text messages and the wife was basically like, yeah, I'm having an affair with my coworker. Yes, we can work on our marriage. I'm very sorry. Let's do what we can. I'm willing to leave my job. And she, the one used rock. What do you mean, Scott? I already covered Corey Richens. Okay, so before I forget this, so they went through all this stuff, and the morning that they went to go on this hike in Hawaii, apparently, allegedly, she was like, I'm not willing to quit my job. She's she does stuff with like nuclear nuclear physicist. Well, I'm probably wrong, so we'll have to revisit that on Tuesday. But when I do cases, and she's alleging that he almost threw her off a cliff and used a rock to harm her. And when I do cases, I don't show every single witness. I'm letting you guys know, if you guys have never watched a full trial with me, I like to take trials that are currently going on and scrub all of the boring testimony that's usually used for foundational purposes and give you guys what you want to watch, which is like the testimony from people who were witnesses, who have crazy information that can help you as a viewer decide whether or not you think the defendant is guilty or innocent. And that's why I can typically get through cases pretty quickly, because I spend a lot of time when I'm not live going through and watching a whole day's worth of court and noting who we want to watch and who we don't want to watch. And you know what? I will say in my defense, with this case, we were a few days behind. And so I was logging off here and going straight upstairs to my room after my live streams and watching a full day of testimony. So I was wondering, like, what went wrong towards the end of this trial, and with me like not knowing which charges were which. And like, I think being behind really freaked me out. And it eventually got to the point that they were doing closing arguments and I was still a day behind in showing you guys the testimony. And I finally just gave up showing you some of that testimony just to get to closing arguments, because I really thought it was going to be a quick turnaround in terms of the verdict. So maybe I'll put out a poll this weekend and see what you guys are thinking. I am overdue for a members only stream. I have just, as you guys know, I've just been feeling really crummy. So I've been relying more on other pieces of content. So I would love to do a members only this weekend. If there are any ideas for my members out there who are watching that you guys would like to see, please let me know. And unless you're going to buy the lottery tickets, I'm not doing scratch offs again. Thank you guys. As we probably get to closing up here, thank you guys so much. Please don't forget to hit the thumbs up on YouTube, to hit the subscribe button on YouTube, and to turn on your notifications, that little bell, and select all, so that next time I go live, you get an alert. If you look up in chat, actually, I'll copy and paste it right now. Join my Discord. Oh, man. I will post the Discord right now for those of you who want to join my Discord and get alerts to when I'm going live that way, because let's be real, YouTube alerts are not the most accurate, unfortunately. I've come to find that out. Join my Discord. There you go. I have been invited on FNL tonight and the last and last week. I haven't felt well, so I haven't gone on. But now that I'm thinking of it, let me add a redirect for later. So back to things I'm asking. Yeah, so if you have any members only ideas, that would be great. Make sure to turn on notifications, like this video, and for those of you watching on X, if you're really enjoying this video, I hope that you will share it. Give me a follow and heart this stream, please. What else? I normally, every Friday, I join my friends for a group stream. And I'm going to go ahead and add it so that if you guys want to come watch me, okay. So yeah, if you guys want to come join us tonight, basically when I exit out of this video and you're watching on YouTube, it'll say like where to go. And that way, as long as I'm feeling well, I will join. Thank you so much. All the comments, all the loves, all the mods that really help me produce this sometimes chaotic. Today was definitely one of the more chaotic streams every Tuesday through Friday around 3:45. And I appreciate you guys helping me grow. It's been a great week, going off with a high note. We got a lot of views tonight. And I'd love to hear your thoughts on this case. I always appreciate comments after the stream. I don't get many. I think that's because I have a lot of live viewers. I'm not quite sure. But if you are watching on restream, or replay rather, please make sure to leave a comment so that I know that you guys are watching. And yeah, I don't want to draw this out too long. I will plan on seeing you guys on Tuesday at 3:45. And if I'm out of bed this weekend, I will plan on seeing you guys for a members only stream. And maybe I'll even stream from bed. No, don't be weird. Nothing risque. Okay, guys, I gotta go. I hope you have a lovely weekend. And be safe and do all the fun things for me. Okay, bye for now.